Well, good evening. Happy Wednesday to everybody. As I always say to those of you on the replay crew, good morning, afternoon, midday, evening, whatever time you're tuning in. We love the replay crew. Glad to see you guys here hanging out with us as we recap the Kowalski trial. I apologize for being late. Tardiness is not something I like to establish as a habit, but sometimes it does occur. I don't know if you guys have been watching any of the live streams, but the Tampa 13 feed apparently missed out a lot of the motions argument. So I was scrambling trying to find that within the law and crime feed to try and catch some of the afternoon. So we had a lot happen today. A lot happened today. And we're gonna break it down. So for those of you who are curious as to what the heck is going on, my name is Rob. This is the channel Law and Lumber. I am a practicing domestic relations litigation attorney, and I have been so for the past 10 plus years. I live in Northern Virginia, and I practice up here, and we're covering a case that has an overlap with domestic relations litigation, and that's the case of Maya Kowalski versus Johns Hopkins All Children's Hospital. They go by JHatch. That's what we're calling them. That's what I'm going to refer to them as. So this is a case surrounding facts that were covered in a Netflix documentary, Take Care of Maya. It involves a child who was admitted to JHatch, Johns Hopkins All Children's Hospital in Florida, for treatment of CRPS after a flare-up in, I believe, October 7th of 2016 is the facts that we have. Johns Hopkins then initiated contacted Department of Children and Families that prompted a removal action, and there's allegations of wrongdoing throughout that process. Ultimately, Maya was retained in the care and custody of Johns Hopkins All Children's Hospital until shortly after her mother's passing by suicide. There are words that I can't allow the chat to say because the YouTube censors don't particularly care for it. So there's things you can't really type, and that S word is one of them. Just because, don't ask me, you got to talk in code. You got to talk in code. I probably used the only opportunity I would have to use that word on this live stream just now. Because the subject matter is sensitive, I've been running a banner below, scrolling so that people, when they join and are watching, aren't really caught off guard by the subject matter. I don't want people to jump in and all of a sudden hear these types of things if they're not prepared for it. Well, how did the day go? Well, I had court today, and I had a spicy judge today. The judge was frustrated with some procedural issues, but we ended up resolving it. It was fine. The temperament of the judge that I was in front of today was nothing like the temperament of the judge and the frustration that was expressed at the beginning of today's hearing. For those of you who are wondering whether you should stay tuned throughout the entire recap, I will tell you that, well, I'm not going to sugarcoat it. I think Johns Hopkins, they got their teeth kicked in today. They got their teeth kicked in today. There's been testimony throughout this trial that's been, you could view it one way or another. You could be skeptical in one direction or the other. Today was all plaintiffs. As you kind of expected to be. We're still in the plaintiff's case in chief. They are still expected to rest tomorrow, but my word, and we get to some of the arguments, you're going to see a lot of heated exchanges, and there's very good reason for it, because Johns Hopkins very, very, very much wants documents to be kept out, very much, and they are not kept out. They are the notes of Sally Smith that end up in the risk management file, and we see them. They're not great. So let's go ahead and get into it with, our spicy judge, Judge Carroll, was frustrated today. He was rather flustered with the plaintiffs, and I'll talk about it in a second. Let me go ahead and get that one rolling. Yeah, let me go ahead and get that rolling so that we can get into that subject matter, because And I sympathize, and I think the judge made the right move here by kind of taking a beat. So closed captioning is up. Closed captioning is up. As a warning to those of you listening, I have this volume gained up 600% because the court feed is awful. However, during these motions arguments, the attorneys move in and out from the microphone. So sometimes their volume is loud, sometimes it's very quiet. I'm saying this because I don't want to blow your eardrums off, because the judge comes in hot. Some of the other people come in hot on the microphone. Before I actually do, I just saw this scroll by. Vez, thank you for the super chat. Thank you, Robin. Wonderful chat to be with on my 52nd birthday. Love to everybody. Happy birthday, Vez. Happy birthday. Happy 52nd birthday. Happy birthday to all of those celebrating their birthday on 10/11 of 2023. And for all of those October birthdays. Vez, happy birthday. I hope you enjoy the most of it. So let's get into Spicy Judge.
First witness this morning, my now hearing is Dr. Corcoran.
No, we're not putting on Dr. Corcoran first. We gonna, and I should have emailed you, but the decision wasn't made till 11:30 last night. We're not gonna call Dr. Hannah. You don't have to worry about that. But it's not gonna change things because we're still calling Dr. Corcoran, but we're not calling him until the remainder of the people that we talked about are taken care of.
So after they spent.
Look at the mouths agape. Look at defense counsel's table right now. Just look. When you're in trial, you are burning the candle at both ends. Fully burning the candle at both ends. You are prepping like crazy. You're going to bed at like 2 o'clock in the morning. It is and the beginning of the hearing, not even before the hearing begins, counsel says, we're not calling this witness that we told you we were going to call.
All evening preparing for a live witness that you told them that was going to be first up. At 11:30, you make the decision, and then you don't even bother to tell them.
Judge,
I mean, how is that?
Midnight, it would have been midnight by the time I told him. I did not believe it would be
Judge.
any good. And
Judge, they sent us other things at midnight. They sent us, frankly, this exhibit list at midnight. So, and we get up early and work in the morning for the day's preparation. So that excuse is unacceptable.
The exhibit list was sent yesterday. It was pared down.
Right, I know, agreed. I'm just saying we were working at midnight, as were you.
and we had prepared for him as well. But we made a decision based on speaking with Dr. Hannah and in preparation as part of trial tactics that we think that the jury has heard quite enough about ketamine and about CRPS, and calling yet another doctor.
What time did you make the decision not to call?
11:30, 10:30, 11:30, because we could not get in touch with him. I actually made the decision earlier, but I could not get in touch with him. And in fact, his office administrator was in touch with me, telling me that he was set to go, and I was like, sure. And we committed it and decided that we don't have the time to put on another 2-hour witness on ketamine and CRPS. And we're down to the nitty gritty here, because we just have to make some tough decisions. And I'm sorry if counsel had prepped on it. They are getting paid to do this.
I'll tell you right now, I guarantee you Shapiro was the one who was prepped for cross. I can almost guarantee that Shapiro, the gentleman in the gray suit, blue shirt, blue tie, I can almost guarantee he was the one prepped for cross.
This stuff, and I've got
That has nothing to do with it.
I'm
It's
just
the whole point of telling the other side at lunchtime who's going to be the next day is so they can prepare. Do you know how wrong that what you just said is? You said you'd even determined it earlier, but hadn't talked to Hannah about it. You didn't even bother to tell them. What's wrong with that?
Judge. It was so late, it wouldn't have made any difference in our view. Why call them? and
I'm
get
gonna
them
take a
to bed at
break.
11:30?
I'm going to take a break. I want the two of you to talk about what people are coming. There's got to be a different way of then deciding at 11:30 at night, 10:30 at night, 9:30 at night, not telling the other side. That is just wrong. cannot happen again. I am so tired of how you're not telling the other side information. It's just wrong. We're going to take a break.
All rise, for the recess.
That is an angry judge. Oh, he's pissed. He was doing some deep breathing. He slammed his papers. He hit the keyboard. He hit the keypad. He was pissed. He has set out a rule. The rule is basically in this trial, whoever is presenting their case in chief, the plaintiffs now, the defense later, they have to give the other side their witness list for the next day by noon the day before. So they have to know what's coming. This judge doesn't want unfair surprise. He doesn't want this was a trial. This was a trial attorney. The judge is a former trial attorney. So he knows that the candle is being burnt on both ends. Now, I will say this. There's something here that I very much admire about this judge. He gave the scolding and he said, I'm going to take a break. I'm going to take a break. Because at the end of the day, he's wearing a robe. He can be personally upset. He can be personally mad, but he's going to take a break because he's wearing a robe and he's not going to let that carry over into how he's going to essentially make rulings from this point forward. And to the judge's credit, after this break, when he came back on the bench, you really would not have guessed that he was mad. So, like I said, I get it. I also understand the plaintiff's perspective here. You're in the middle of trial. You have been burning clock and you're afraid because you've told the judge you're going to rest by Friday. And you know that every doctor that you've put on the stand, you've had them there for hours. You have had difficulty in making headway in your case. So you're trying to plan your timing accordingly. You are trying to plan the remaining hours that you have to finish your case on time. So it's one of those things where I understand from the plaintiff's perspective, and I understand the frustration of the defense. I think the judge's main frustration is tell him, I don't care if it's 10 o'clock at night, 11:30 at night, midnight. I don't care if it's that late. You tell the other side that you're not calling that witness. Then at the very least, and you don't do it. You don't do it when you're on the record. You walk into that courtroom, all the attorneys are there. There's back and forth that occurs during this period of time. You can make that announcement to them. You can walk over and say, hey, Mr. Shapiro, just an FYI, I apologize for not texting you last night. I only learned this at 10:30. We're not going to be calling Dr. Hanna. I know that you probably prepped for his cross-examination. I did not intend this as a slight to you. This was honestly a decision I had to make. I didn't really want to make this decision because I would love to have his testimony in, but I don't have the time to call him. Do you know how much that would have gone over, how much better that would have gone over with the judge? Like 9 million times better. So judge goes, timeout. I need a break. I'm going to step off the bench. He comes back and you would never imagine.
Which one they're using?
It's JHACH 19,511.
Is it a identified exhibit, trial exhibit number?
I don't see one on this copy I've been handed, Your Honor.
Okay, in my Zoom feed, I have a person, I assume is a witness, Regina Schimmel.
This is Beata's sister, Your Honor, first witness.
All right, so judge is cooled off. He's taking this little break. He's relaxed. He's feeling good at this moment. We're back on the train. I appreciate the hell out of that for a judge doing that. You get mad, you take a minute, you come back. You guys might have seen this in the Darrell Brooks trial where the judge stepped off the bench a lot to cool and calm herself, because that's what they're supposed to do. Ms. Schimmel is Beata's sister. She testified via interpreter from Chicago, speaking in Polish. This was a damages witness. It was a damages witness. It really wasn't that. There wasn't a whole lot. The only thing I really gained from this was that there really was a very, very large fear within this family dynamic of bureaucracy. I think that the part that I gathered, or the part that gleaned the most out of this, was that Beata and Ms. Schimmel's father was incarcerated for a period of time without explanation by the state. So it was, I didn't know that it was the most impactful thing in the world. And you know what? This is a good comment. My apologies, Cat Lewis. I will do that. I will do that. I will also try to speak quieter in recognition of that. So thank you for making that observation. I sometimes get a little excited, and sometimes when I have the mic gained up, it can be a little bit loud. But I do want to fast forward to, we had depositions after this witness, and usually depositions are really, really boring. You watch the video, they testify. If anyone who covered the Depp trial or anything else, you watch the video, they testify. It is boring. Not today. Not today. This was not boring. Wait, hang on. I want to catch this. Stephanie, I did want to call this out. It wasn't a waste. I didn't say it was a waste. I did not say it was a waste. I just, of the things that I can cover in a recap, with everything else that transpired today, the things that I wanted to cover from the legal perspective were a lot of these depots, and I don't have enough time to go through everything. So it's not a waste. I thought she did well. The kids don't get to see their family because mom was the primary connection between them. So this is Laura and Voss. So let me go ahead and put the little banner up so we know who we're talking to. And this is by deposition designation.
There you go.
You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record.
Laura Ann Voss,
And is that an MD?
D.O.
And what the DO stands for again?
Doctor of Osteopathy.
And at your present hospital, are you on any committees?
Yes.
What committees?
I am on the ethics committee. I am on a pediatric surgical performance improvement committee.
Okay.
Okay, I want to fast forward to the relevant part of her testimony. So we got in that she's on the ethics committee, and questions were asked about whether any of the stuff that was transpiring would rise to the level that there would be an ethics complaint or investigation. But then we get to about 122, let's go with 122.15. And I'm going to go ahead and speed it up to about 1.5 times the attorney. They both speak slow, so about 1.5 times we should be able to hear pretty well. All right, closed captions are turned on. This part, we're going to listen to this until about 1:35. So a couple minutes of this.
Investigation into the ethics of how she was treated.
No,
Would you agree with me that using the term ketamine girl is a bit dehumanizing?
it basically sort of as a euphemism to not use her name in a text.
Okay, well, you're not answering my question. In retrospect, wouldn't you say that the term ketamine girl is a bit dehumanizing?
I probably could have used a better choice, but I was trying not to use her name. I'm not aware of that. No.
Can you say, as you sit here today, that you didn't refer to her as Maya in different conversations to other doctors? On the phone, that is.
I'm not aware one way or the other with 100% certainty.
How many ketamine girls were there at All Children's at this time?
Well, I had used that as a euphemism because it was unique and given her history. And
Did you ever refer to her as ketamine girl to her name, to her face,
no,
to her mother,
no,
to her father?
no.
I removed the
So
labels.
how's
People
ketamine
read the
girl not an
transcript.
identifier if MK is the only girl being kept there because of ketamine?
I see it more as an identifier for people that would be familiar with her case, but not something from somebody outside to be able to connect.
All right.
connected specifically to a person.
You're sure that none of the nurses or social workers or other doctors also referred to her as ketamine girl from time to time?
I have no idea.
All right. You said, sorry to say my prediction was correct. You were predicting you were predicting Beata's suicide, were you not?
Prediction probably was not a good word, but more related on my previous experience of a case during residency. So it may have been more of a speculation than a prediction.
You have a doctorate level education, do you not?
Yes,
All right. So when you say words, you choose what words are appropriate, do you not?
I like to think that I do, but in a
Anderson, for all the criticism I have of Anderson, his depos have been really good. They've been really good. They've been really good. I am very interested to see him on cross. Very interested, because I think he struggles with direct, but the way he poses these questions. Yeah. And for those in the chat, yes, using her name might have been a HIPAA violation. But the point he makes is the ketamine girl thing. You could have referred to it by the room number, could have referred to it by some other euphemism. You didn't have to choose ketamine girl.
text, sometimes you don't think and edit and re-edit. And as a human, you sometimes use words that probably would not be the best words to use.
Okay. So tell us when you say my prediction, please define my prediction, what it was.
I had a previous experience during residency where there was a child who the court had determined was Munchausen's by proxy, and that mother had committed suicide. So it was based on a previous experience.
And where did that happen?
That happened at All Children's.
And when?
I believe it was in my internship year, which would have been 1994 to 1995.
And tell me what the facts were, without mentioning names, obviously, that you believe caused that mother to commit suicide.
I don't have the details. I know as a resident, I believe I might have seen that child one time in the emergency room, and then there was an investigation and she had committed suicide. And that's basically all of the details that I know of that case.
Who were you predicting this to? Who was the recipient of this prediction?
Some of it was my own thoughts, and I believe I had maybe a passing conversation after caring for Maya with a coworker just saying that I had had a previous experience, and that's what had happened.
So by the time Beata committed suicide, you had already gone through one with a mother committing suicide, right?
I knew of one, yes.
And you knew the signs of someone who was about to commit suicide from that experience, did you not?
I didn't have any involvement with that patient or family during that period of the investigation and afterwards. I had seen her.
And yet it came immediately to mind when you heard that Beata had taken her own life, did it not?
It came to mind.
All right. And then you, there is a response, or is this you? I know we did the right thing, but this is really effed up. I feel bad. Is that you, or is that Dr. Tepa Sanchez?
That's Dr. Tepa.
And did you share her concerns that this was effed up?
I shared my concern that I felt bad about the situation.
All right. So you felt bad. And then you expressed this by saying, don't know all the details, but I think the courts and the psychiatrists finally called it what it was. I had another mother do the same thing. We definitely did the right thing for the child. All right, taking this last sentence, we definitely did the right thing for the child. The right thing being what?
That I believe that as a group and an organization that we advocated for Maya, raised concerns, and allowed the process to continue for the appropriate people to look into what was going on in the hopes of having a good medical outcome for Maya.
You do know that Maya did not have a good medical outcome for more than 3 years and still suffers from pain, do you know?
I'm not involved with her care, so I don't know directly what's been going on with Maya.
Did you ever check on Maya to determine whether the statement was correct? We definitely did the right thing for the child.
What do you mean by check on?
Call her, follow up in any way.
No,
Talk
I
to
did
her.
not.
Talk to Dr. Rosenauer, her pediatrician.
No, I had no follow-up contact with Maya.
Did you ever call Dr. Wassenauer to ask him what his feelings were?
No,
And then it says, OMG, that means, oh my God.
yes,
And then, well, I really hope she has a chance of a better life now. Is that you or is that Dr. Tepa Sanchez?
that's Dr. Tepa.
And did you believe that Maya was better off without her mother?
I think it's sad when any child loses a parent. However, you know, if the investigation was proceeding and found that that was leading to harm for Maya and that Maya, you know, perhaps Maya now would have a better opportunity to have some other therapies and not be under the high doses of drugs, to be able to succeed at school, to be able to do well.
So you actually believe
Anyone else get the impression by her body language that she is very, very, very much regretting those text messages? Oh. Always text and email as if it one day it will be read out loud in court, and you're not sure of what context it's going to be read in. Does she regret the words? Yep. Did she still say them? Also, yes. Wow. And, you know, it's one of those things. That's an impossible question. That is an impossible question. Answer for this text message. How?
believed that Maya Kowalski was doing something harmful to her daughter?
I think that the process of evaluation was underway, and that is that we allowed the system to work and the people that were appropriate to make those investigations and determinations were involved.
All right. And then it says, well, I really hope she has a better life now. That's again, Dr. Tepa Sanchez.
Yes,
Do you have any remorse to this day? Evidenced by anything in these text messages?
I feel sad about the whole situation, and I feel sad that she chose to take her life. But I'm hopeful that Maya now has been able to be more active and participate in her life and do more things.
Okay. And you saw her toes, feet turned inward
Answer.
towards each other? The dystonia?
I don't recall if I ever examined her feet on night call.
You never saw her feet. Okay. When you saw Maya, though, she was perfectly civil and nice to you, was she not?
She was, she didn't really talk much to me that I recall. She was on her phone the first time I saw her. She was playing on her phone. She did not personally swear at me.
You saw her 10 times, and each time that you saw her, she acted like a 10-year-old, 11-year-old girl, did you not?
Some of the times she was sleeping.
Well, I think 10 and 11-year-old girls sleep occasionally.
Correct.
So, but the point being, your medical records do not reveal any denial of her being in pain. So when you say, let's me see what she does with pain tonight before doing CT, you realized that there was, I don't want to call it a threat, but a possibility that that performing a CT could cause her some discomfort, aggravated pain numbers. True?
Yes, there was a potential for that.
So you were the chairman of the ethics committee at this time in 2017, were you not?
Yes.
Still to this day, there has been no retrospective on what happened.
Up to the point that I was at All Children's, there's not been an investigation. I cannot testify to what has happened since I left.
Ouch. Ouch. All right, plaintiffs. It's the first knockdown in this bout. So you've got them on the mat. Let's see if you've got anything left in the tank. So next we move on to Jay Perno. Yet another deposition. Again, depositions are supposed to be boring.
Perno by deposition.
We're gonna try to do the lights again.
Oh, and I moved the little box up to the top right so you can see the name, but you can still read the transcription.
Dr. Urquid, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Morning, doctor. Please
Morning.
state your name for the record.
Joseph Perno, Perno.
And you are a medical doctor?
Correct.
And where do you work?
Johns Hopkins All Children's Hospital,
And when did you start there?
2003.
Prior to the acquisition of All Children's Hospital by Johns Hopkins?
Correct.
And that occurred in?
2010 or 11.
All right. Is it true that you never actually sat on the risk management committee?
I don't recall attending in 2016 or 2017.
So you weren't there, at least as far as you can remember.
As far as I can remember, I was named a member of the committee as chief of staff, but as chief of staff is a volunteer position, I was still working a full clinical load and couldn't attend every meeting I was invited to.
Okay, so caveat. This is obviously not his first deposition with this particular case. He's really quick with the answers. He's very quick. It's not really processing the questions. I think he's heard them before. And he's obviously and notably frustrated plaintiff's counsel. And again, I go back to Depot designations. If this was in front of the jury, I dare say he would not be acting this way.
So as chief of staff, how did you keep up with what was going on there?
Well, as chief of staff, you get invited to every single meeting in the hospital. You pick and choose the ones that are important for the role of the medical staff to attend. And I don't recall ever attending the risk management committee.
But since you were chief of staff, you had, I am assuming because you're here, some control or management of the risk management committee?
No, I had no role other than to attend and listen to what's going on.
Well, how was that information then communicated to you of what happened or what was going to happen?
Is anything the medical staff need to know about? I'm the liaison to the medical staff. They would communicate with me if there's something that was significant for the medical staff to know.
That's a big point. That's why I waited till he got there. That's a big point. He's the liaison to the medical staff. So if there's something important, he's the one that communicates it and does the information back and forth. So we're going to fast forward a bit to 202. And again, we're going to be listening a little bit longer because we need to.
So the answer is no.
Everyone, we're constantly monitoring our quality of care through multiple indicators, whether it's frontline staff, physician staff.
Dang it. Hang on. Let me rewind another minute or another couple seconds because I missed that point. So two minutes. Here we go. I remember to unmute. We're 30 minutes in and I haven't muted myself yet.
Is it true that the board, based on the recommendation of the MEC, can allow someone on board onto the hospital to make an examination on an emergency basis without submitting their application for privileges?
That is exactly what I was referring to when I talk about emergency privileges. There's a shortened process where we do the basic checks for quality and safety. And yes, it is a recommendation. All medical staff decisions are finalized by the board. But yes, that's the emergency privileging process you described.
Sorry, I'm gonna make a note. Who was there to review what was happening to Maya Kowalski in real time?
So there's no need for a review in real time if the care is going well.
Oh, baby.
So the answer is
Oh,
no.
baby.
Everyone, we're constantly monitoring our quality of care through multiple indicators, whether it's frontline staff, physician staff, resident staff.
We're gonna go real time with this because he's a fast talker. And I feel like part of it, I was listening to it on like 2x and oh my God. On 2 times speed, this man sounds like even worse. I do see there's 3,200 of you in the chat right now. I really love having you guys here. This case we're on day 13 of these recaps. Today was a big day for the plaintiffs. If you do like what you're seeing, please hit the like button. If you wouldn't mind, consider subscribing. Cost nothing. Just subscribe. That way you can get notification of when these recaps are coming. This trial is getting into a very, very interesting phase of trial. So, Mr. Perno, Dr. Perno, we're slowed down to regular speed so you don't sound like a sped up, not nice person.
Staff, we're constantly looking at it. So if there's no red flags, there's no need to do a review of every single case.
What's a red flag?
If there's a concern with the care that we're giving.
Give me some examples.
If there's a concern for inappropriate medication use, prolonged stay in the hospital, discharging too soon, inappropriate floor, meaning need a higher level of care, something along those lines. There's some
He just identified every red flag with Maya Kowalski's case. He just identified all. It just boom, boom, boom. If there's a concern about the care, medication administration, wrong floor, prolonged stay.
generalities of things we're always keeping an eye on.
All right, let me ask you about some different things and ask you whether they would meet the threshold for the risk management committee, and we'll work through the other ones. A patient such as Maya Kowalski being kept by the hospital against her and her parents' will for 7 days. Would that reach the threshold of something that would be reviewed by risk management?
And no, I mean, risk management committee meets quarterly, so that would not be appropriate.
So would it be reviewed retrospectively?
I do not know.
Would it be reviewed by the patient safety committee?
Probably not.
Would it be reviewed by the standards and credentialing committee?
Definitely not.
Can you think of any other committees that might review a patient being kept against their will at the hospital?
I don't believe we keep patients against their will, but it would probably be more of a team meeting with the care team and the family to discuss best process.
All right. The patient being,
I got to get 5 more minutes in, so I'm going to speed it up back to 1.25.
prohibited from seeing her priest, would that meet the threshold for the risk management committee?
Again, the risk management committee doesn't function in real-time decisions. It's a quarterly meeting.
Well, then,
Sorry. Pause. Massive impactful statement. Do you remember the deposition of Kathy Beatty, who said that risk management was telling her to do all of these things? Right? Remember that testimony about how she was in communication with risk management, how risk management was telling her to do these things? The chief of staff just said that risk management does not operate in real time. They meet quarterly. And deliver information down the chain. Kathy Beatty said risk management was doing that in real time. This doctor's like, no, they don't. This doctor might sound arrogant. He really might sound arrogant, but if I'm on the jury, based on my observation of Kathy Beatty's deposition and his deposition, even though this guy is kind of he's doing his thing. He's wearing Carolina blue in that suit coat. I'm not a fan of that. I went to NC State. No. My personal thoughts aside, credibility-wise, I find this guy more apt to tell me the truth than Kathy Beatty. Just saying. That's me. I imagine that some of the jurors might feel the same way.
who at the hospital checks to make sure that the floor staff, the doctors are actually involved, are doing the right thing?
So we have risk managers who are involved on a day-to-day basis that will interact with the staff as necessary. We have social workers for scenarios that you're kind of leading towards that would work together with the care team to make sure we're giving the highest quality care.
What if it's the social worker who's actually doing the things that are highly questionable, if not illegal?
We have physicians, we have risk managers would be involved, and I would like to say our social workers don't perform illegal activities.
Who makes the decisions or oversees decisions about compliance with court orders?
I would say that's probably our risk management department.
So in terms of, let's just say, there are facts in the record that Maya Kowalski's priest was prohibited from seeing her in the hospital. You would agree that that violates Maya Kowalski's rights?
I wouldn't necessarily agree to that, and I don't know why the priest was denied, but I wouldn't agree to that.
Okay, so who was there then to review the actions of a nurse or a doctor or a social worker who came up with something like that out of their own head? Who was the next level to check to see whether that was appropriate standard of care?
It would be probably a team decision between the caregivers, the social work, the nursing staff, and again, likely risk management in this scenario.
And who's the superior to risk management?
I don't know. I would guess our legal counsel, but I don't know. I'm not in that.
And who does your legal counsel report to?
At that time, it was the president.
And other than the board of directors, was the president the highest authority of the hospital?
Yes, the president at the hospital, yes.
Let's ask about the child being stripped down to her underwear, short shorts.
Told you it gets worse.
Against her will, and photographs being taken of her without any court authorization, any authorization or notice to the parents, and against both the parents and the child's will. Would that be the type of thing that would meet the risk management threshold?
No, because I would consider that part of our standard care and treatment plan. We often will take pictures of patients to document for the medical record.
Folks, if you're new to the channel, I have this lovely gift. It was given to me by Law Talk with Mike. Well, by people who had seen Law Talk with Mike and thought that every lawyer that live streams and discusses trials should have something that makes the noise I'm about to make. That would be a screaming goat. That would be a screaming goat. Let's rewind. Let's rewind and listen to the actual question again. So, Dr. Perno, we're going to give you another shot. Listen to the question. And then his response.
Yes, the president at the hospital, yes.
Let's ask about the child being stripped down to her underwear, short shorts, against her will, and photographs being taken of her without any court authorization, any authorization or notice to the parents, and against both the parents and the child's will. Would that be the type of thing that would meet the risk management threshold?
No.
Listen to the question. Minor child stripped down to their shorts and training bra, held down against their will, no court authority or consent, no child consent, no parent consent, and not even a moment of pause by Dr. Perno.
No, because I would consider that part of our standard care and treatment plan. We often will take pictures of patients to document for the medical record.
Make sure I get this right. Standard of care. So
We're giving you another shot.
Johns Hopkins, All Children's Hospital, standard of care could include stripping a child down to her underwear and photographing her in a private room against the child's will, against the parents' will, and without notice to the parents, and without any court order or legal authority to do so. Am I correct in that?
I think the legal authority is the consent to treat. It's part of a treatment protocol. Many children object to things we do for them, right? If I'm suturing a child in the ER, they object. If they were put in.
Oh my God, Dr. Perno, you're making it worse. Dr. Perno, you're making it worse. Dr. Perno. Dr. Perno. Is there an ambulance? Can we call an ambulance for the doctor? Is he in the hospital right now? Can we get him treated? Who is this individual? People are asking. This is the chief of staff for the hospital. This is the chief of staff. This is the chief of staff. This is the chief of staff.
An IV in their arm, they object. So a child's objection, I think is difficult. We work with them. But yeah, it's taking non-patient identifiable pictures to help with a medical record, whether it's bruising, whether it's rashes, whether it's injury. It helps enhance the medical record.
Reminder, these photos were not in the medical records. That's a reminder. Reminder, the photos were not in the records.
So it's part of a standard treatment plan.
But in every one of those circumstances, the parents are notified and give their consent. True.
We have consent to treat. So once they give us consent to treat and examine, that's all part of a physical exam and treatment plan. So yeah, that consent had been already given.
Well,
Oh my God. Oh my God. Did you guys just hear that? Did you just hear that? We had consent to treat. So, based on what this doctor just said, I am now on the jury. I'm now on the jury. And my understanding is that a representative from the Johns Hopkins All Children's Hospital has just said that when I admit my child to that hospital and sign a consent to treat, I don't get to withdraw that consent at any point in time during their standard course of treatment. Even if that standard course of treatment involves forcibly removing the child's clothing and photographing the child against their will and against my consent. Because when I first brought them in, I consented to the treatment. If I am on the jury, that is what I just heard. If I have a kid and I'm on the jury, I am very, very upset by what I just heard.
can the doctors put a child into a surveillance room for 48 hours under false pretenses of testing without parent consent?
Yeah, I think we choose rooms for our families all the time without consenting families.
Oh my
And
God.
if we feel it's part of the treatment plan, I don't see that as a separate call out either.
What possible benefit to the child is it to put them in a room where they cannot reach the commode for 48 hours, knowing the child cannot walk, and keeping her in that darkened room for that length of time?
Are you asking about this specific patient? I can't speak about this specific patient. And I'm not sure exactly what you're trying to get at.
When is Baltimore consulted in terms of standard of care?
Very.
That's it for Dr. Perno. That's it for Dr. Perno. Okay. What are we calling this for Hopkins? If that first Depot was a knockdown in a boxing match, oh, my pause game is on point tonight. Look at that. If that first Depot was a knockdown, is this a knockdown like an 8 count? Is that what it is? I don't know that we're at TKO yet. I don't know that we're there yet, but I think there's an 8 count. And that deposition, man. It gets worse. Well, if you want to know if the jury cared about it, If you want to know if the jury cared about it, here we go. Where are we? Yeah, I'm there.
Something that risk management should consider.
Yes,
That's happened.
It's kind of an abrupt end, but that's the end.
Okay. Are we have another deposition or?
We do.
I'm sorry?
Yes, we do.
So I'll leave the lights as is. And your next,
The next deposition is Dr. Anthony Napolitano.
hold on one second. I'm sorry. If there's a question, go ahead and write it out.
This jury has seen, I think, 3 or 4 depots by now. They know that there's no one there to answer the question. They flag the judge down. They get the judge's attention to ask a question. Do you think that if they had a screaming goat, that goat be screaming? Guys, it's still the morning. It's still the morning. The level of holy crap that I was mm-hmm.
And Mr. Whitney, while the jurors writing out, from a timing perspective, are we okay with the next deposition?
I think you said the breaking point is 11:30.
11:25.
It will be fine.
Doctor, would you raise your hand for me, please?
Hold on a second.
So the next question.
Thank you, Jules. Jules is in the courtroom, guys. She's been giving us info from the courtroom.
Looks like there are a lot more. Are there other questions? I'm sorry.
So the judge calls them up, calls counsel up, puts on the white noise machine to read the questions from the jury. I really wish I, in this moment, had the ability to read lips, because I just realized that you can see, but yeah. This is a good question. LVG dead girl. Can they edit a depo to only have part of the answer instead of the complete answer? No.
Hey, members of the jury,
maybe.
one of your number had a couple of questions. Obviously, with a deposition, I don't have a live witness here that can answer that. But as you've seen, the attorneys are very aware of the questions that were raised, and I suspect they will address it in due course. And let's proceed with the playing. Hey, is the lights okay? Do we need to dim it down some more? Okay, thank you.
All right. Before we get to Dr. Napolitano, can they edit the depo to only have part of the answer instead of the complete answer? It depends. If there's an objection made that's timely within the deposition, then there might be the ability to edit it. But realistically, no. Once the question is asked, that's the opportunity for the other side to object to the question. And once the answer is given, you really can't unring a bell, not in a depo. So I don't really see that. Guys, I see the super chats you guys are sending in. I want to make it through the morning session. And I'll get to the questions and super chats before we begin the afternoon. Dr. Napolitano is not that long. So let's go ahead and listen to the relevant parts of his testimony. I really only have one note with him.
Doctor, would you raise your hand for me, please? Do you swear firm testimony you're about to give the truth, whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
Anthony Napolitano.
Dr. Napolitano, do you understand that you are appearing pursuant to a directive by the court that the defendants produce someone with knowledge regarding the risk management committee operations and issues regarding chain of command and control?
Important comment here. Dr. Napolitano is what we call a corporate designee. This is an individual. When you sue a corporate defendant, the corporate defendant, you have to, when you wish to depose the corporation, you have to designate. The corporation has the opportunity to designate somebody that within that hierarchy can answer questions on the subject matter that you wish to inquire. So if it's corporate structure, if it's corporate governance, the corporation says, we elect or we say that this person knows our procedures enough that they can testify to it. So this is a corporate designee who is testifying to risk management. That's the important part about this. The other witnesses that we heard were on committees. They were important. They had roles, but they weren't the corporate designee. This is the person who speaks for the policy of the hospital.
Yes,
And have you ever served on the risk management committee?
yes.
What years?
I would say 2014 through 2019.
And what was your position, if any?
I served as chair of the Department of Pediatrics.
Who else in 2016 was on the committee with you?
It would be the chair of the Department of Surgery and members of the risk management team.
Say,
Point for the microphone. Point for the microphone. Microphone scored a point. There's my mute button. There it is. 56 minutes in. All right. I'm fast forwarding through his depo because realistically, he didn't give a whole lot. What he did was he kind of reaffirmed what we heard from the prior two depositions as far as what the policies were. This guy was just the official guy who made it official. The part of his testimony I thought that was relevant was when we get to 233, 30, 233, 30. Where are we? We talk about meetings here. We'll go to 233.01.
Hospitalist medicine, genetics, infectious disease, neurology, rheumatology.
well, if you had, and then you would have had control over all of the doctors we mentioned from one department or the other, would you not?
Thank you,
I'd
Steve.
have a good deal on the medical side.
All right, and then how often would you have a meeting in 2016 with the heads of the departments?
We try to meet monthly. Not everybody would attend, but we try to meet monthly.
And in terms of the discussions, do you recall any discussions, even in the general terms, about a child that was being held by court order in the hospital for a long period of time?
No, that would not come up in the division meeting.
How many times have you ever heard of a child being kept at your hospital for over 3 months against their will?
I'm not aware of that.
And so still, if that in fact is true, that was the circumstance, Maya was being held for over 3 months against her will and her parents' will at the hospital, that was not a significant enough event for any of the department heads to bring up?
No,
I see. So it doesn't really matter if the child feels that they're a prisoner, the patients feel the child is a prisoner. You're going to stick to your, what did you call it, methods of care?
yes,
I don't think I'm premature this time.
And this was from May 11th, 2023.
Yikes. Ouch. Ouch. Oh God. Oh, that was bad. That was so bad. Let me do this. Let me go over some of the questions real quick, and then we'll go to the afternoon session, because the afternoon session, that's where a lot of the notes get in, and that's where you see the argument for Mr. Hunter. And Mr. Hunter there's a reason he made the thumbnail today. He was very opinionated about a lot of things this afternoon. A lot of things about this afternoon. I'm going to try to get questions, and I'll save the rest. I do want to make it through the content. I want to make it through this. There's a lot of you guys watching. I will pull up super chats and I will go through all of them at the end. I want to get questions so that I can get on with the afternoon. I apologize for those of you who sent it. I would try to pull up timely stuff now. Let me just scroll. Della, thank you. For Rob, best analysis on the case. Thank you. Matt Bond. I have to pull this up because Matt Bond has been here every night. Matt Bond. Good day, spiffy legal mumbo jumbo talkie brother from another mother. I am so used to saying that, and I'm so happy to say that every night that you've been here watching this case. So this is a good one too. AG, did my first training deposition today. I see what you meant by about Depos scarring. Yeah, Depos scarring can be brutal. And it trains witnesses. They get concerned when they go to testify in real life because they're so worried about what was in the transcript that's going to be used against them. That's part of what fed these doctors when they're answering. They've been deposed multiple times. There's scarring. Some of them handle it appropriately, like Napolitano. He was direct. Like, you didn't like the answers, but he was direct in the answers. The answers were yes, no, monthly. They weren't long drawn out answers. Conversely, deposition scarring can occur in another direction where it's deposition vomit of the mouth, word vomit, which would be Dr. Perno. Perno. Yes. Dr. Perno. Had to double check myself because for a second, don't think that way. That was deposition word vomit. That was, you've asked me this question before. I'm going to give you the long answer. I know the question you're going to ask. I'm going to give you the same answer. They both yield very different results, but Depos scarring is a real thing. H.J. Luna, directed verdict means that there's no disputable issue of fact to be presented to the jury. That on any number of the counts, the matter is taken out of the hands of the jury and the judge enters verdict in favor of either the plaintiff or the defendant. That's the directed verdict. Let me do this, pull this down, go to the questions I've got. Marsha for the generous super chat. Thank you very much. Rob, love your recaps. You got me interested in this case. I have told this case is a big deal. It's a bigger deal than we think it is. The courtroom I was in today is Juvenile and Domestic Relations District Court. This is the same courtroom, the same court level in Virginia that handles these types of dependency actions, the removal proceedings. And I will tell you this, I've been practicing law for what, 12 years now, 12, 13 years. I walked in today with a different reverence, with a different understanding, not understanding, a different appreciation for the tasks that we put before these courts. You get jaded. I try not to. But this case is important to me. And the effery is really, really bad. Rob, what time will Anderson have left for a cross during defense case? It's getting a little scary. Nope, judge is going to let him cross. He'll get the cross. They've been doing well today. They have been doing well today. Adrian, I cannot disagree with you. I think the plaintiff definitely landed some knockout punches. Regina, good question. What if the jury has questions for the person in the deposition? Are those possible to respond? No. What the judge does when the jury proposes those questions at the conclusion of the deposition is he reads them aloud to the plaintiff and the defense, so that if there's an area or subject matter that they feel they need to cover to answer those questions, they can either call a live witness or introduce a document to try and answer those questions. So the deposition deprives the jury of the ability to ask the questions that they have been asking throughout this trial, but the counsel on both sides still have the benefit of knowing what the jury wanted to know, and they can present it to them. I think. Keep going. I started this one. Lita, thank you very much for the very generous following of the channel. You've been great in the chat, great commentary. All of you guys have been great about this. Today was right up my alley. Worked in hospital administration forever, hospital bylaws, med staff, policies, quality, risk, credentialing, support Maya. It was a day of a lot of policy, but I thought it was going to be boring. It was not. Joel and Elliott, Rob, the behavioral arts about these depots. Stat. I hadn't thought about that. Depos, not really. Sally Smith live. I might be giving Spidey a call. You know what? When I go on the next one, I'm going to text him and say, I think there's a doctor I need you to look at. and see if he can't give a little bit of his take on it. Because Sally Smith is one I've been waiting for. Oh yeah. Depos don't give you they don't give you enough to analyze it because they're cut up. You don't see the transition from the question to question. Yeah. So wait, risk management couldn't have ordered Kathy Beatty in real time. Does this mean there's potential she lied under oath? I have conflicting testimony. Both of them are sworn. Which one do I believe? That's my question. Casey Cat, Beata's court-ordered psych eval cleared her of all Munchausen's by proxy claims. So why do they get to act like she had Munchausen's by proxy? One of the interesting questions that was asked, I can't remember if it was today. I think it was today, but I forget what witness it was. Dang it, I forget it. But it was asked during either deposition or live testimony of the fact that JHatch is a children's hospital, which means that they are not equipped. This was testimony that they were not equipped to give diagnoses to adults. Munchausen's by proxy is a diagnosis given to an adult. So I found that curious, and I wonder if any of the jurors caught that as well. But I did hear that in testimony today. So let me see here. Make sure I've got different ones. Anna, thank you for the generous super chat. Hi, watching you in the morning from Singapore. Hi, Singapore. Your streams have been my companion while I work. I'm glad for that to happen. So enlightening hearing the intricacies of law. Also, mad props how your production quality leveled up. Well, until I muted myself on accident. But thank you, Anna. AG, if I were on the jury, I'd be horrified. What are the implications for adult patients here? There are no adult patients here. It is a children's hospital exclusively. Consent to treatment means they can literally do anything and call it treatment. That was what that doctor said. That bothered the hell out of me. I cannot imagine what the jury was perceiving in that moment, hearing that. Those notepads are probably just filled with notes. The Chuggy Show Live, why does he make me think of the actor John Hamm? Maybe. The mouth of gate might have been it. Read, if Maya was no longer in her parents' custody, who gave consent? Arguably DCF. But in that particular instance, Kathy Beatty is saying that she was told by risk management, not DCF. Now you have risk management saying we only met quarterly. We didn't have real-time instruction. And when asked the question of what happens in these instances, they say, well, we follow the social worker. Anderson asked the follow-up question, well, what if the social worker is doing the thing that's wrong or illegal? And his answer to that was, well, I trust that there's no one on staff that would do anything illegal. That was his answer. So right now, that depot was something else. Ashley Miller, did CV mean risk manager and not management? Or okay. Kathy Beatty, did she mean the risk manager was the one that signed off on it? Well, she didn't say that in her depot. She didn't. And hold that question for a second. We're going to revisit that after the afternoon back and forth. Because I think the jury is going to start creating connections in their head over who's the one providing the instruction. They're going to start making that connection real quick after today. Real quick. Like I said, Sally Smith. I am very curious. Shiraz, are the sidebar transcripts for civil trials? There are, but they're only released towards the end and when people order the transcription. It's remarkably expensive to do so. Get the question. When the question for witness and they're giving you the info you need to make the case, is it an adrenaline rush? When you're questioning a witness and they're giving you the info you need to make the case, is an adrenaline rush. I would say that being in court, period, is this weird mix of anxiety, stress, adrenaline. I mean, I can't eat that day. And my brain feels like it's firing on 9 million cylinders, like just moving full power. Yeah. When you feel like you're on the right track, when you feel like you're in a rhythm, it's I don't mean to say like euphoric. The best way I've ever been able to describe it is I was an athlete in high school and college. And there are those games where you will start playing and something just you even in warm-ups, you have a rhythm. In lacrosse, which I played in high school and college, if I was too amped up, I would play like crap. If I was too relaxed, I'd play like crap. There was this weird, I don't mean to like say the word vibing. Like you're in this weird place where you're smooth. You understand. You can speak in a cadence. You're rhythmic. You've got a method. You've got something going. When you're there, when you reach that point, you are in the zone, and there's nothing like it, because and when you realize what you're doing in advocating for a client that needs you to advocate, I mean, it keeps you there. Now, at the end of the day, at the very end of the day, after that, you're dismissed. You run on that adrenaline for about 35 minutes to upwards of 2 hours when I'm in active trial of several days. But after that 2 hours, I forget my own name. My brain has fed off of all the adrenaline, and I've in longer trials, when I've done 2 trials back to back, like 1 week, by the end of that second trial, I had a fever. I think I had dropped like 8 pounds. And I just slept for like 2 days straight. It's not the healthiest thing. You guys can be critical of that, but your body really didn't really, when you're in that headspace, your body didn't really allow for that. It's really pretty interesting. A lot of people don't get that about lawyers. They think that they're just there and they say these things and they're doing their job, but they're invested. They're invested. Their heart's there, and you can tell when they argue. Hikaris, what if I'm in the jury and I have no poker face at all and show my disbelief left and right? Then that's what you do. Now, the judge might tell you to please try and keep your thoughts to yourself, but if you do, you do. Knitting with me, didn't they say Sally Smith on Depot today? They wanted to try to get to her. They didn't get to her. Depot portions tomorrow, but I think the hospital's going to call her live. So, Ange Torres, transcript piggy bank. These sidebars are there. There's going to be a lot in these sidebars. I can guarantee you there's a whole lot in these. And then again, Vez, contribution to order transcripts. There's going to be a lot in the sidebars. So, Island, thanks for the info. Beata's psyche eval completed 11/20/21/2016, wasn't officially filed until after her death on February 1st of 2017. It cleared her, but only after the fact. So, yeah. Let's get to this question. Patty F. I wonder if mom would have ended it if Maya was in medical foster care. All had attorneys during DCF process. Strange it still took so long. No, these reunification plans, once the court moves at a pace that is intolerably slow, the system is not very well designed to handle spur of the moment reactions. You can get a hearing, an emergency hearing, but you still need a 24-hour notice. A lot can happen in 24 hours. So with these cases, I think there were hearings every month, every 2 weeks or something like that. So I wouldn't say that the court process here was necessarily long. I will say a lot transpired in that time. That was a lot of, from the plaintiff's perspective, a lot of messed up conduct. So we'll get to that. Let's go ahead and zoomy zoom. Zoomy zoom zoom. Set a zoom zoom zoom. Okay, we have to go to law and crime. I know, guys, law and crime, who just got purchased. I don't know what that means, but sure. This is fair use. I have an errant hair. Oh, sure. Why not? You guys know my hair is usually a mess. Oh, it's not going down. That's weird. Okay. All right. So now we get to the afternoon and we get to some of the motions argument, which is really pretty interesting. Dread part. Wesley Rob's hair in full. Yep. Revolt. Uh-huh. So, afternoon session. We are now in motions and argument. So let's go ahead and put that label up. There's no below line transcription. There is no closed captioning for this one, and it is gained up.
We're going to address, folks.
Judge, it'd be the motion to limit Dr. Corcoran's testimony that we made reference to before the unscript.
And at some point again, Judge, if you've had the chance to review it, the Williams motion, you have to find out about those.
Well, Mr. Hunter has the floor right now.
Thank you, Your Honor. May it please the court. We've made a motion to limit or exclude the testimony of Dr. Joseph Corcoran. The basis of the motion, the main thrust of the motion is exclusion, and it is based on section 766.102, paren 7.
Okay. Motions for exclusion. A motion in limine, as one of my friends with very bright purple hair calls it, a motion in lemonade. A motion in lemonade. What is a motion in lemonade? Motion in limine is a motion to limit testimony or exclude testimony. In civil trials, generally speaking, in civil trials, these motions must be made 2 weeks prior to the trial. In Virginia, 2 weeks prior to the trial. So this motion is being brought as this witness is standing in the hallway trying to enter the courtroom. So there's frustration. But again, there was frustration this morning against the plaintiffs. So we just have frustration. We're just gonna be frustrated. So let's listen to the motion in lemonade or motion in limine.
For statutes. As Your Honor has heard before in this matter, section 766.102 provides for the qualifications under which testimony may be offered by an expert witness in a medical malpractice case. The threshold requirement is that the expert witness have reviewed under subsection 5 of the statute all pertinent medical records, which this witness has testified he has not done. Above and beyond that, however, and more importantly, to thrust this motion, under section 766.102, paren 7, anyone who is testifying in a medical negligence act.
What is on his belt? Mr. Hunter, what is that? Hang on. Spartinos? Interesting. No, it's not Spartan. It's not Spartans. What is that? Weird. Oh, wow. Wow. Chats, you guys are really good. Squirrel. Sorry.
766.102, paren 7. Anyone who is testifying in a medical negligence action against a hospital or healthcare facility may give expert testimony on the appropriate standard of care or other non-clinical issues administratively if he has substantial knowledge by virtue of his or her training or experience concerning the standard of care among hospitals of the same type as the healthcare facility or hospital whose acts or omissions are the subject of the testimony and which are located in the same or similar medical communities. Now, I paraphrase the statute there, Judge, but the thrust of the statute is that the threshold substantively for the competence of an expert to testify on administrative and non-clinical matters against the hospital is the question of whether they have substantial knowledge and experience in the same type of hospital. This witness has never practiced in a children's hospital outside of medical school over 30 years ago. He has never been a CMO of a children's hospital. His experience as a CMO or senior executive official in a hospital setting comes as a result of having served as a CMO, chief medical officer, in a general hospital, a children's hospital, a general hospital, a different type, in a different medical community than all children's hospital in St. Petersburg. Can we ask the doctor to speak?
Dr. Corcoran, if you.
Dude is literally walking into court. Literally walking into court. And Hunter's like, no, I want to make this argument. The problem is, it's a last ditch argument. I was wondering why they were pushing so hard, because when he was making this down the fine line of statutory interpretation, I was thinking, this is a stretch argument. It's a hell of an argument to be making. I was going, Hunter really, really, really doesn't want this guy to testify. Really doesn't want him to testify. Why? Why doesn't he want to testify?
You could wait outside, please.
In any event, Judge, that's the thrust of the argument. The record is established through his deposition testimony that he's not familiar with the different levels of licensure under Florida statutes for different types of hospitals. He is not familiar with the differences in specialty as opposed to non-specialty institutions. He has no familiarity with the disease processes
You might laugh.
among pediatric patients. In fact, he's testified he's not a pediatrician. He's never been a pediatrician. He has no knowledge of the diagnosis and treatment of CRPS, the use of ketamine, or any of the other clinical issues that are issued here. He is by training a osteopathic board certified OBGYN with no pediatric credentials whatsoever, who has never practiced significantly in a pediatric hospital.
Do pediatric hospitals use a different coding system than other hospitals?
Coding system in what respect?
For billing purposes?
I'm not aware that they are, but on the other hand, he's never been provided our billing records.
Yep, he should have been.
Okay. Anything else, Mr.
Not
Hunter?
according to his deposition. That's what we have, Judge, and the alternative part of the motion is that his testimony be limited to those matters with respect to which he.
Oh, Iris, he's qualified. What Hunter left out was a whole lot. Hunter left out a whole lot of information.
Can furnish familiarity. If Your Honor is suggesting that perhaps if he's properly informed regarding billing, that would be a potential exception. But as a matter of statement.
When was this deposition taken of Dr. Corcoran?
Deposition was taken, Dr. Corcoran, sometime recently.
August
Judge.
1st, 2023.
He was the one that, Your Honor, let them add.
Sorry.
At the last minute. It was taken like.
Whitney, Attorney Whitney, coming in hot. Coming in hot. He's pissed.
You said August, I suppose, yes, that's right.
August what?
August 1st.
And so this motion is coming in on
Get the transcript before the deadline.
transcripts can be had in a day or two. I'm just wondering why, because we had so many of these hearings before trial. Why, when we are with lots of people here and people ready to go to testify, that we're having this conversation now as opposed to, the day or the week before trial even started? Why wasn't it filed by then?
Judge, we thought we would file at that point where we had a complete picture of what he had reviewed and we had the opportunity to put it together. And
The deposition was on August 1st.
Sorry?
I said the deposition was on August 1st. Why wait 2 months to file the motion? The reality is you want me to make a decision, which, these motions take a lot longer than the snap amount of time that I'm being given on this.
Judge, in years past, we would make this motion after voir diring the witness at the time on the witness stand.
Pause really quickly. Melanie, that is exceedingly generous of you. Very, very generous. Thank you very much. Florida mom here, adopted sibling group of 3 from foster care, a nightmare also had a very, very, very sick kid at the hospital. At that hospital, the doctor saved him with no social workers, but he could have easily been diagnosed as at Munchausen by proxy. He is now 32, healthy and happy. Love your program. Melanie, thank you for sharing that. Thank you. That is very kind of you to share that. I'm sorry that you went through that, but from what I'm gathering and what I imagine, I can't be too sorry because that's what made you who you are today. So it's a complicated system. A lot of people live through it. And I'm glad that you made it on that end. And now people are healthy and happy and that you're sharing your story. You are welcome to share, be here. Thank you for sharing. While this is reloading, there's 4,000 of you watching. If you wouldn't mind hitting the like button, it'd be very much appreciated. Or subscribing.
To exclude various doctors and opinions have we had
We
in
have,
this case?
Judge, we had a number of them. We had a number of those in June, July, and others in August. This doctor got deposed late. He never got a report to us till very late. And
His report was timely on June 10th, 2023.
I'm gonna hear from your side in a moment.
Whitney. God bless that man. God bless that man. He is on fire.
I don't know what to do, Mr. Hunter, because I feel like I'm being jammed on this. He's here, everyone's waiting, and you're asking me to make really substantial rulings on things that I would have liked to have actually had some time to think about and to, read it in more detail.
Judge, I regret making you feel that way. It's not my intention. There's a number of us getting jammed about a number of things on this matter.
Mr. Whitney, what's on your side?
Answer a quick question. 4,000 record for this trial. Yes. Previous record was when covering Murdoch. I think it was, there was one day when I picked up for Emily, I think we had 30,000 people in the chat, or 13, or it was 30. Upwards of about 12K. Not major numbers, but really big numbers. And this is the biggest for this particular case, which makes me very happy. This case is important. I want people to see it. I want people to trust that I can cover this case in a way that doesn't have us all cringing. That's what I want. I want people to see that this case matters and that you can watch a recap and not be turned off and not be offended and not be scarred. I'm not going to run you through the gauntlet and make these inappropriate remarks. So I'm very glad to see all of you here watching. Mr. Whitney, let's hear, bud.
The relevant section of the statute is 766.
Well, first off, tell me what this doctor is going to be testifying to. Let's start fundamentally.
Well, that's right there, Mr. Anderson's question.
He is a hospital administration expert, Your Honor. He has analyzed the rules, procedures, routines,
Our producer.
Forms, releases, and the internal documents of Johns Hopkins All Children's Hospital. He is offering opinions about failure of the systems within the hospital to prevent many of the situations that happened here, including Kathy Beatty and treatment of Maya Kowalski and the overall treatment of her through her stay. He is opining as to whether the hospital had sufficient control to advertise itself as Johns Hopkins All Children's Hospital, given the fact, as just testified to by, I believe, either Dr. Perno or Nepolitano, that there's absolutely no control whatsoever over them by the Baltimore company. He's also testifying about the lack of training.
Hang on. Do we get a hot mic moment? We're all going to be really quiet for this. So remember, we are at 409.53. 407.34. Everyone be really quiet.
I don't know. How many motions in limine to exclude various doctors and opinions have we had in this case?
Judge, we had a number of them. We had a number of those in June, July, and others in August. This doctor got deposed late. He never got a report to us till very late. And
His report was timely on June 10th, 2023.
I'm going to hear from your side in a moment.
Did I miss that because it wasn't in slow? Let me go back to normal speed.
I'm going to hear from your side in a moment. I don't know what to do, Mr. Hunter, because I feel like I'm being jammed
Okay,
on this.
I didn't hear it. I'm catching back up
He's
to
here.
49:53.
The aggressive behavior was known, and how unusual it is for the type of report that was filed against Ms. Beatty to be in a hospital. And the fact of threats of physical violence by one employee upon another are a very grave allegation in a hospital, particularly a pediatric hospital. He will testify, and thus that Ms. Beatty should have been sent back if they wanted to keep her for significant training, which they failed to do, or she should have been released, or at the very least, she should not have been put in to be whatever you want to call her towards Maya Kowalski with very little control. He's going to testify to what you heard from Dr. Perno.
There's Jules. Jules, love the coat today. Love the coat today. It's the black and white check coat. That's Jules in the chat.
And Dr. Nepolitano, the fact that there was absolutely no real-time review or risk management of events as they happened or within close proximity of them happening sufficient to put a halt to things that were ongoing. He will testify to this was a box guarding the hen house situation because of the way that Johns Hopkins has set up its monitoring system such that you had people who worked together all the time, if not totally, were counted on to report about each other in the event there was any violation of Johns Hopkins internal rules. He'll testify concerning the internal policies and procedures of Johns Hopkins All Children's Hospital. Instances include their elopement routine, their 2 or 3, their minor leaving AMA routine, their failure to express the patient and family rights and comply with them in the handling of the Kowalskis. That is a summary of his testimony, and it is set forth not only in his deposition, but in his report. I'll find the date of the report. It was filed timely, as co-counsel has stated, but he filed that, and he also filed, the court may recall, an affidavit, I believe, in support of punitive damages, in which he went over many of these points. I think almost all of these points. And that affidavit is April 12th, 2023, prior to one of the final motions on that. So the defense has had an opportunity to receive a report, an affidavit, and depose him extensively, at which point he covered these issues. All of the things he's testifying to are in evidence.
If you need further on statutory argument, please let me know.
Plaintiffs really want him. You see that chest heave? They want him. They want him fierce. Hunter doesn't want him fierce. This argument, this witness, and what the witness is going to testify to is a big deal.
I'm still trying to read, and that's why I said I got jammed on this one. I don't know how you want me to do a quality job at making well thought out decisions without giving me the time to do it. I mean, I can make rulings, but I like trying to think through what's being requested of me, get a chance to actually like read the depositions. And
thank you, Judge, for making the comment. Thank you, Judge, for making the
Some of
comment.
Stuff that you're hearing is clearly outside of the pleadings that have been put forward. Count 11, for example, has been walked away, it's a walk back. He's being put forward as an all-purpose expert regarding a very limited specialty hospital, and that, I suppose, is the point. I apologize, but I didn't perceive that as being a matter that required that much forethought. And if that's my bad, that's my bad.
Well, if you're making the argument that he has never been the chief administrative officer of a specific children's hospital, and you're contending that that is the requirement under sub 7 of the statute for him to be qualified, is that the argument?
Creed, they're going to lose that argument 10 out of 10. 10 out of 10, they lose that argument. on this issue, on this witness, that argument's good. That argument's done. It's not going to win. Not on whether to allow a witness when you have deadlines of motions in limine prior to the trial, when you have a timely disclosed expert well prior to the cutoff date, and you have an eve of testimony motion to limit or prohibit that person from testifying, that motion loses 10 out of 10. That argument on appeal loses 10 out of 10. Now, the next one is his big argument. My freeze game is on point today. My freeze frame game is on fire. Now, the next thing on the appeal issue, on the chapter 39 immunity, that's their strongest point. But I think the judge, and I'm trying to be as impartial as I can here, because I'm trying to walk you guys down to what the minefield is in trying this type of case. But I will very clearly say that I think the judge was right yesterday when he made the observation that a lot of this mess can be attributed to J Hatch and their own making. They chose to hire Sally Smith directly, knowing she was contracted with DCF. Was that done intentionally to blur the line with Chapter 39? I don't know. I'm not going to speculate on that. But it blurred the line. So I don't, as it stands right now, on the legal merits, nothing that I've heard in this trial so far would. I mean, Alton Byrne is a retired judge, from my understanding, and I'm not disparaging or discrediting what his argument's going to be at the appellate level. I just don't see it going anywhere. Not with what we've heard, unless we go down a road that is very far afield from where we are. They're going to appeal, period. They will. I just don't see that appeal going a whole lot. I don't see it going very far. So,
Argument you're making?
Yes, sir. I'm making the argument that someone who's going to criticize the standard of care of a specialty hospital under the statute needs to have substantial knowledge and experience demonstrated of their ability to know and be familiar with the standard of care for the same hospital. That's the clear black letter law of the statute.
What do the case?
well, Hunter stepped in it. Mr. Hunter, you just stepped in it. You said that's a clear black letter law. That's clearly what's on the statute.
To say interpreting the statute, since
There's very few cases that interpret this statute as opposed to the statute under 766.102 per 5. But under 102 per 5, the cases are very clear that it's got to be that the expert witness against or for whom a witness is being testifying has to be in the same specialty. This requirement is essentially the same thing as applied to hospitals.
Your Honor, subsection 7 begins, notwithstanding subsection 5.
considering that I wasn't given the opportunity really to think about this or review, can someone give me a case interpreting the statute so I can actually?
Can someone give me the law? Because you didn't file a motion properly, and you're asking me to like make a spot ruling. Can someone give me, like, catch me up to speed? Get me up to speed. And Whitney, I have been remarkably, look, that man is a research attorney like nobody, he's good. Hopkins attorneys are good too, but I want you to look at every person at those tables, front, back, and in the first row. Those are attorneys for Hopkins. Grandma got moves. Yes, you do. Grandma, you do got moves. Appreciate your channel. Been following you since Johnny Depp trial. Grandma got moves. Thank you. That's very, 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 very kind of you. Very generous of you. $50 super chat. Thank you for doing that. So, Grandma got moves. Let's see if Judge got moves. And Mr. Whitney, let's give this judge some law.
See what courts have said about the statute.
The primary case they cited, the only case they cited, is Santa Lucia versus Levine at 198 Southern 3rd 803. And that case does not discuss, this is the relevant statute. It doesn't even discuss 766-102. It discusses a separate part of the statute under 766-103. So we don't yet have a case.
there are actually two cases we cited, Judge. Neither one of them construes this particular subsection of the statute. That's why I said what I said a moment ago. The point, however, is that it was amended in 2013 to require the similar, it tightened the similar healthcare provider requirement for giving expert testimony and required expressly that you have to have an orthopedic surgeon, for example, to testify against an orthopedic surgeon.
What was the law number?
I'm sorry?
What was the law number that was the change? I mean, these are things that I would normally have done so I can actually understand what the legislature has done.
The laws of Florida citation
Judge is pissed.
2013-108 and 2011-233. I believe the latter one in 2013 is the one that tightened the similar healthcare provider provisions, subsection 5.
Anderson loves that stapler, man.
Run it from there.
That's me nuts. Ready for the call out? If you're ready for the call out, here it comes.
So 213-108 laws of Florida. Doesn't say what you said it says. So what's the next one?
2011.
I don't know what to do, Mr. Hunter. I don't feel like I am ready to make a decision on this issue. I feel this is way too late. I mean, if just looking at the statute, what you're saying is because he's never been a pediatric hospital administrator, he is not eligible to qualify under the statute. I think you're probably reading the statute a little too narrowly, but again, I haven't had a chance to do it. So if I have to make an on-the-fly decision, I'm going to overrule that because you haven't shown me any case law that would construe it that way, or if I got to make a decision without any chance of reflection, then I'm going to say no.
Judge, I would simply point out to you that this plain language statute requires substantial knowledge and experience with respect to the same type of hospital. That's the purpose.
Or Whitney, look at him.
That's the objection we were making.
Well, I don't believe the word same is in the statute.
I'm sorry?
Look at him. Whitney wants it so bad.
Your Honor, it does say at the same type as the hospital in subsection 7. I wanted to clarify the factual point, which is that
Same or similar communities, and he was the head of what, Brandon?
he was the head of Brandon, correct?
It's all part of
Which
Tampa
had-
Bay.
He was the chief medical officer of that hospital, which has
Hold up. You see the window in the back? You see the window in the back of the courtroom? Just over Mr. Whitney's shoulder? That is Dr. John Corcoran. That's that is the doctor, John Corcoran, they're arguing over. They are arguing over whether to allow this man to testify. And they have said, can you wait outside? And he's right there. Oh, he's just patiently waiting. Yeah, he's been there the whole time. Because the judge said, wait for a second.
a pediatric hospital within it. In fact, he affiliated and collaborated with Johns Hopkins All Children's Hospital in establishing the standard of care at Brandon.
Oh, here you go. This is the part where Whitney tells you the rest of his curriculum vitae.
Is that true?
Not to my knowledge.
A pediatric, he was the head of Brandon, correct?
It's all part of
Which
Tampa
had-
Bay.
He was the chief medical officer of that hospital, which has a pediatric hospital within it. In fact, he affiliated and collaborated with Johns Hopkins All Children's Hospital in establishing the standard of care at Brandon.
Is that true?
Not to my knowledge. He certainly didn't say that in his deposition. He did testify in his deposition that at Brandon, his hospital, not him, he didn't service the contract. His hospital hired pediatric ER doctors and pediatric neonatal intensivists to come in and run portions of their hospital. But he also said that he had nothing to do with either making or servicing those contracts. So I don't construe that as assisting them in making the standard of care. If Your Honor look at the statute, it's a matter of his having knowledge and experience in the same type of hospital and in a similar community. It's a two-pronged test. Now, the similar community is wishy-washy here, but the same type
It says
of hospital is
or.
clear. I'm sorry?
It says or, right? Not and, it says or.
It says testimony and which are located in the same or similar communities at the time of the alleged act giving rise to the cause of action.
And if you're suggesting that Hillsborough County and Pinellas County are not the same or substantially the same,
No, sir, I'm not suggesting that. I'm saying that what I'm suggesting is that the same type of hospital is the primary standard here. And he has not demonstrated that level of knowledge. This would.
so you agree it's the same community?
Yes, sir.
Okay, so you're only talking about,
Same type of hospital. And Judge, with all due respect, this objection would be perfectly appropriate at the time he offered the opinion.
Except for the court said prior deadline.
Just focusing for a moment on the four
Anderson.
communities, in addition to being the chief medical officer of Brandon and pediatric
For those of you who missed it, Anderson said, except for the fact that the court set a prior deadline. So there's that.
hospital there and affiliated with Johns Hopkins in those efforts. He was also division chief medical officer for HCA Far West Division, and he oversaw Sunrise Children's Hospital in Las Vegas. So Las Vegas and Tampa are substantially similar.
well, we both have football teams. Both had John Gruden as a coach.
I would suggest that there's a similarity in there.
No, I-
He's reading the statute out
Where else
loud.
has this doctor been? Remind me.
Hospital Corporation of America.
Yeah, he's been an executive with HCA Hospital Corporation of America. In that role that I mentioned, he was the division chief medical officer. I think he'll say he oversaw 10 hospitals in that role. And the one I mentioned was Sunrise Children's Hospital.
It's Hospital Corporation of America, the largest hospital.
I know what HCA is.
Oh, God.
Mr. Hunter, what I'm hearing is from a factual standpoint, he may qualify even under your definition. That's about the best I can give you right now, given that I wasn't given time to prepare for this. Mr. Altenberg.
If I may, beyond his qualifications, I'm going to be instructing my trial guys to object a lot because of the scope of the pleadings. There is no risk management claim under 766.166 expressly in count 8. Nothing in there alleged a management thing. It was diagnosis and having a treatment plan is what's in count 8. In count 4.
So now we know who's driving the ship. We thought it was Hughes. Because Hughes has been in the backseat, but Altenburn is driving the ship because you just heard him say, I'm going to be instructing my guys to do this. So Altenburn's like, I'm going to be instructing my guys to object. And the judge is like, I'm kind of done. I know you want him out. You tried a bullshit argument. I didn't let it fly.
14,
So-
the smorgasbord is now down to a negligent training claim only. And it only references 766.166. In paragraph, I believe it's 170, say it's sort of like this. And so I was listening to opinions that might have been appropriate when count 11 was in, but count 11 was voluntarily dismissed. So anything about the training or the not the training, but the background on Miss Beatty and whether she was disciplined in the past was not relevant to this.
Your Honor, as you're aware, we
Excuse
have.
me.
Yeah, let Mr. Altenberg finish,
No, I thought he
please.
was done.
At any rate, we need
Ooh,
to keep this within the scope of the pleadings.
Altenburn doesn't do that. That was chippy. This is a big witness. They do not like.
Or not the training, but the background on Miss Beatty and whether she was disciplined in the past was not relevant to this.
Your Honor, as you're aware, we have.
Excuse me.
Yeah, let Mr. Altenberg
No,
finish,
I thought he was
please.
done.
At any rate, we need to keep this within the scope of the pleadings. And it sounded from what I heard, numerous things were going beyond anything that is left at count 14. And there's no risk.
Whitney, get your hands out of your
management
pockets.
at count 8, except by incorporating that which is in count 14.
Are you done?
Yes.
All right, hold on a second.
Are you done? Whitney is chomping at the
What you're
bit.
telling me that Dr. Corcoran, when he was administrator with HCA, had under his constellation of hospitals, a pediatric hospital?
Yes, Your Honor. And a CMO of Grand Regional Pediatric Hospital within it.
Now, how about Mr. Altenburn's point about the scope of the pleadings?
Sure. The scope of the pleadings also includes punitive damage claims under 76872.
On battery and false imprisonment.
Correct. And we have to show and demonstrate the ratification or active participation or condoning of these actions by management. And he can speak to all of this because of the violations of internal policies, the failure to train Catherine Beatty, which is led in her anger management issues, allowing her to continue over this child, leading inevitably to the battery and false imprisonment, all the other misdeeds that she committed against Maya Kowalski, as she's testified to here. So management and risk management are materially relevant to our case here. The issue of risk management not only is subject to our pleadings, but has been up to the second DC as the court's well aware. So the nexus between risk management and mismanagement of this hospital has all been part of this case for now 2 years.
There's a smackdown. It's already been appealed. It's come back. We won on appeal.
Hold on a second, please.
Reference is being made to Ms. V's prior arrest.
No,
No, it was not.
That's out. And I think I struck that last night as well.
I
All the questions.
You did, Your Honor. I thought I saw it referenced in someone's testimony or affidavit.
That could be, that could be.
I missed what are you arguing?
Your Honor, additionally, on the pleadings, outside of the punitive damages argument, count 8, which is the medical malpractice count, incorporated count 14, which is the negligent training, supervision, and ratification of the physicians.
Training, not negligent training.
And in the lead up to trial, there was an agreement between Mr. Altenberg and Mr. Elliott, I believe, he'll confirm, to collapse count 14 into count 8 to avoid another jury instruction on this issue.
There was an offer and there was never an acceptance because they never gave me jury instructions that could fit there. There's no agreement on that.
Then in that case, count 14 is still an active count. So
For negligent training only under a common law theory backed up by 766.166 and a reference to a Bill of Rights, which is a piece of material only admissible to establish a common law standard of care. There is a statutory Bill of Rights provision in the Florida statute. It has no private right of action. It has a different penalty.
Holy crap. Do you understand how important this is to the hospital? They're fighting this on every single level. Every single level. Every level. ABQ Cat. I brought this up because it's a good question. How is the hospital's exception to this witness not out of order just because it's untimely? Untimely is one reason you can disregard a witness. But the judge wants to appeal proof his decision. So he said, not timely, that's one reason. Not only that, but I find they qualify. That's what the judge is doing here.
We consumed all this time. The bottom line is, I guess he's testifying, and there's gonna be lots of objections, and I'm just have to do the best I can with the rulings on the fly. Are there any other motions that are gonna be very substantive like this that I need to know about so I can be ready for them? Thank you.
from the plaintiffs, there will be.
Well, let's get them quickly because
We will.
I guess we didn't get any exhibits, so.
Do you want to handle one or two, or just want to? I'll leave it up to your honor.
Are they needed for this witness?
Couple of them.
If they're needed for this witness, then let's do them. Mr. Whitney, which one or ones are we talking about?
Just a moment, just if we could.
I'm sorry?
If we just have a moment to decide which one Mr. Anderson left for this witness.
We don't argue things that either already in evidence or we don't need from this.
All right, we'd like to address exhibit 2277, pages 245 and 246. Straight up.
No, we don't want this one. That's boring. Let's fast forward. It's not that one that we want.
Brought to their attention.
It's so it's after the doctor begins testifying.
Again, Judge, off the top of my head, you remember.
One issue would be the issue that arose with Catherine Beatty's email that we tried to have admitted and the factual assertion that there was a delegation.
The email you sustained?
Yes, sustained it with the additional instruction that the defense could try to prove up a delegation.
All right, so Corcoran takes a stand, and then we take a break. We take a break in a minute. But Corcoran takes a stand, and we get some of his background. Some of his background is impressive. He bolsters a lot. But I do. when he starts testifying and telling you about his background, I want you to remember what Hunter just argued to the judge about why he should not be able to testify to the policies of the hospital, or whether the hospital was, because Hunter made the argument that J. Hatch is a children's hospital, and therefore this person who's only worked in other hospitals, and oh my gosh, heaven forbid, he hasn't practiced medicine in a long time, shouldn't be able to opine on how the hospital is run. So I want to be very clear. Listen to what he says his credentials are.
Hi, can you please state your name for the record?
Yes, sir. I'm Joseph Corcoran,
MD?
DO.
DO. And where do you live?
I live in Tampa, Florida.
And have I asked you here as an expert in hospital administration to advise the jury on your review of the policies and procedures at Johns Hopkins All Children's Hospital during the relevant period?
Yes, you have.
I'd like you to give the jury the background, a little bit of your background training and experience for offering opinions here today, particularly well, why don't I let you start?
Good afternoon. So I'm Joe Corcoran. I'm an OBGYN by background. After finishing my residency in Philadelphia, I practiced in Sarasota for about 12 plus years, from 1991 to 2003. I'm board certified by the American College of OBGYN. I spent my first 3+ years working for a large practice. In March of 1995, I started my own practice with the idea of keeping it small and boutique-y. That didn't last very long, and the practice actually grew fairly quickly. By the end of my term with the practice, I believe that we had 3 physicians, 3 nurse midwives, and 4 nurse practitioners serving a variety of offices, one of which was here in Venice. The main one was in Sarasota near Doctors Hospital. In 2003, shortly after I became a dad, I had what should have been routine back surgery. There were complications after the back surgery that ended my clinical career. I was unable to continue to stand, bend, lift, twist. Obstetrics is a fairly physically demanding specialty, even though the babies are fairly small. So it took about 2 years for me to get better. And I did that recuperation at home in Sarasota. In 2006 or 7, I started a business education master's program at University of Florida in the Warrington College of Business. I graduated with a Master's of Science in Entrepreneurship and Innovation. Shortly after graduation, I was recruited to a healthcare think tank in Washington, D.C., known as the Advisory Board. It's been around since the early 70s and is now part of Optum Healthcare. I joined in November of 2008. My first day on the job was the day before we elected Barack Obama as president. So it was really kind of neat to have a front row seat to the development of the Affordable Care Act. I had nothing to do with the legislation. We actually helped hospitals and large medical groups know how to change in this new paradigm. I was with the advisory board through the beginning of 2013. At the end of 2012, just prior to the election between Barack Obama and Mitt Romney, I was asked to deliver an address at the Longboat Key Club in Sarasota, and talking about what would a second term of Obama versus a first term of Romney look like for healthcare. There were some executives from HCA in the audience. A conversation started that evening that ultimately led to them offering me the opportunity to work with HCA Healthcare. HCA Healthcare is a for-profit hospital company. It currently has about 180 hospitals, I believe in 20 or 22 states. So I was offered the opportunity to become the chief medical officer of Brandon Regional Hospital in suburban Tampa. It's about a 350, 400 bed hospital at the time. I was in that role from 2013 until 2018.
Did Brandon, I'm sorry to interrupt, did Brandon have pediatrics as well?
Brandon always had a pediatric capability, but during my tenure, we actually developed what we referred to as a hospital within the hospital, so that we had a dedicated pediatric emergency department.
He created, like, he didn't just run a children's hospital, he created one within the hospital
that had a separate entrance from the adult emergency department. And we had a dedicated floor for pediatric patients, including a pediatric ICU. And of course, being a heavy OB hospital, we always had a neonatal unit as well for newborns.
Please continue from there.
Thank you. So in the fourth quarter of
Oh, I don't disagree,
2018,
Jules. He
based
went way
on some
sideways.
progress that I had a hand in at Brandon Regional, I was given the opportunity to assume a larger role within the company. And for better or for worse, that included a move out west. I became the division chief medical officer for the Far West Division, which has responsibility for about 35 cares of site total, but 5 acute care hospitals in the state of California, 3 acute care hospitals in Las Vegas, Nevada, including Sunrise Hospital, which is about 800 beds today. If I'm not mistaken, the Sunrise Children's Hospital, which again has a separate entrance and a separate emergency department, accounts for 206 of those beds. I was in that role for about 3 years, including when the nation learned about COVID. One of our hospitals in the Silicon Valley actually had patient number 2 in the whole country. So we were kind of winging it. We were figuring it out. And a lot of what we did in managing the early cases in California and some in Nevada actually set the foundation for how the rest of the company managed COVID across as it spread from the West Coast. I was in that role for about 3 years. I left the role because, quite simply, it came down to a job that I loved and a family that I adored. My wife and my 2 kids were never able to move out west, so I was commuting about 2,000 miles, 5 hours by air, and my kids are my world, so that became unsustainable. So at the end of 2021, I moved back east. And in the early part of 2022, I accepted an opportunity to step away from full-time service to HCA Healthcare and take on the opportunity to serve interim roles. So they would drop me in basically as a consultant, and I would work 3 months at a time, engaged at a specific hospital, trying to address more specific problems.
So did Sunrise?
So I'm going to fast forward to voir dire. I'm going to explain what that is. I want to answer the question. Jill Prince, is he just a professional witness now? What is he getting paid to testify? Oddly enough, he has never testified as an expert witness before, ever. They go through some of the background of how he became involved in the case, and he goes far afield. He talks about his background like he's talking about his family. But he's never been an expert because honestly, you don't really need an expert to say that what's wrong is wrong. If that makes any sense. This dude is a proxy. He had a hell of a lot of credentials. He's run hospitals everywhere. He has set up pediatric care units. He has set up emergency rooms. He has run, from an administrative standpoint, all these hospitals. He ends up meeting plaintiff's counsel via a family friend. And it's kind of immediate, like, this guy is an expert in the field. So you ask him some questions. You say, have you looked at this? Well, yeah. What do you think? It's horrible. Would you be willing to testify to that? Yeah. It's not that hard. I doubt this man is getting paid hardly anything. Actually, Hunter doesn't ask that question at all, because I think he might be doing this pro bono. The he's made money already. He doesn't care. But it was interesting because Hunter goes about immediately objecting. And it makes it very clear that he wants to voir dire this witness. And I want to catch that part of the voir dire, and I'll explain what that is when it comes to the witness. We've heard of voir dire when it comes to jury members, but not when it comes to witnesses. So let me see. We hear you?
Yes, I have not practiced medicine at a children's hospital, and I apologize for not being more clear before.
No problem. And you haven't worked in a children's hospital?
Hang on.
That's not entirely true because, again,
Rewind.
Brandon Regional.
Good afternoon.
Voir dire of a witness. What does that mean? When you have an expert witness testifying, that expert can be either qualified as an expert or just testify as a fact witness. But in either event, when you're trying to qualify an individual who's testifying as an expert in their field, you have to put on their credentials. Usually it is stipulated to by the other side. They've seen the credentials. They're like, I agree. This guy's an expert. This gal's an expert. They're going to testify. They're an expert in their field. I'm not going to go through the torturous process of trying to cross-examine their credentials. Hunter does. Hunter wants to voir dire this witness in front of the jury. He wants to cross-examine the credentials in front of the jury. One of the reasons you don't want to do this, why do you not want to do voir dire in front of a jury? Because every question you ask either sounds, it can have the possibility of sounding dumb, or you give the witness more opportunity to explain their background and experience. Hunter, I don't know whether this is licking his wounds from the earlier motion. I don't know whether this was planned. I don't know what the purpose of this is, but this voir dire, in my opinion, does not go the way that he wishes it to go.
Good afternoon, sir.
Just a few questions at this point. As I understand it, your first billet, if you will, as a hospital executive, was at Brandon Regional Hospital?
Yes, sir. My first hospital-based leadership position. Yes, sir.
And before that, and to the present day, you had not practiced in a children's hospital outside of medical school, correct?
As an obstetrician gynecologist, yes, I have not practiced medicine at a children's hospital, and I apologize for not being more clear before.
Not a problem. And you haven't worked in a children's hospital since medical school?
That's not entirely true because, again, Brandon Regional had the children's hospital within the bigger hospital, and Sunrise Hospital has Sunrise Children's Hospital.
Okay, well, let's compare and contrast.
Okay,
Brandon Regional Hospital is a general hospital, correct?
that is correct.
Is it licensed as such by the state of Florida?
Sir, I'm not aware of the license.
You don't have any idea what the licensure classifications are?
That's outside my wheelhouse. As a
Would you have any reason to doubt that it is licensed as a class 1 general community hospital?
That's outside of my wheelhouse. I wouldn't even be able to comment.
Do you have any idea?
No idea.
Okay, we can't agree that it takes adult patients.
It does.
That's primarily what it does, correct?
It does.
And it does adult surgery.
It does.
And the hospital within a hospital is just one floor of a general hospital, correct?
When I was there, it was limited to one floor. Yes, sir.
And that wasn't there when you started. It was something y'all developed.
That's correct.
Okay. It has nearly 400 beds.
Correct.
It's in a community as a community hospital, correct?
Yes, sir.
Doesn't have a reputation for referrals far outside as a tertiary care institution.
Actually, it does a lot of intake for some of the specialty work that it does, particularly in neurosurgery and other services that aren't maintained at most community hospitals.
Motion
And they're
grant,
adult
Kelly.
services.
They speak fast.
Yes, sir, but we also took in transfers from newborns.
Okay. So if you had problems with a newborn, you transferred it, correct?
Well, we kept most of them at the hospital.
But if you had a complicated newborn, you transferred it to a children's hospital, correct?
For the most part, yes, sir.
Okay. Now, do you have any idea what the number of beds at all children's has?
I believe it's in the neighborhood of 240, 250.
What is their licensure? Do you know?
I have no idea, sir.
Do you know what the acuity level of the beds at all children's are?
I do not.
Do you know how many NICU beds they have?
I do not.
Do you have any idea how many PICU beds they've got?
I do not.
To talk about your hospital in Las Vegas, you never worked in that hospital, did you?
I was in the hospital on a weekly basis, but I never had an office in that hospital.
You didn't have day-to-day responsibilities for being the CMO of that hospital, correct?
That is correct. I was that CMO's boss.
Okay. And you were over the top of him and didn't have command of the executive team, did you?
Not command, no, sir.
Okay. So you were not directly responsible for operations in that hospital. You were supervising what your employee did in that hospital, correct?
I was accountable to the work that was done there.
Okay.
Big distinction. And I credit the witness for not losing that.
But not responsible for the day-to-day operations.
Okay, that's my point. Okay, so how many beds was that hospital?
The hospital writ large is, I believe, just over 800 beds, and I believe just over 200. I believe it's 206 of those are part of Sunrise Children's Hospital.
Is it separate?
The hospital is a multi-block complex. Sunrise Children's has an entrance on the south side of the complex.
Tina, wonderful, wonderful point. Are we having a hospital measuring contest? If it feels that way to anyone else, that's how it felt to me. Are we really going to do this? Are we really going to say he's not an expert because the number of beds differed in some way? That the children's aspect of the hospital was a part of the hospital? That he ran the whole thing rather than the day-to-day operations? Are we really gonna do this? And if I'm the jury, I'm going, what the hell are you doing? He is just explaining more and more why you should listen to him. This was a miscalculation. This was a miscalculation. This was really, it came across as petty.
The adult hospital has its entrance on the northwest corner. The emergency room is, both the adult and children's emergency rooms are on the east side. So I don't know how to answer that. They are, you know, when you're leaving one hospital and entering the other, but there are contiguous hallways.
Are they separately licensed?
To my knowledge, they are.
And how are the licenses classified? Do you know?
Again, that's above my pay grade.
Okay. What is the acuity level of the beds at the Children's Hospital?
So the Children's Hospital actually has every conceivable level of service, not level of service, every conceivable clinical service, including open heart. They have a very active open heart program. They have neurosurgical, pediatric, open heart, pediatric neurosurgical. Sunrise Children's is the tertiary care hospital for the state of Nevada.
Okay.
If Hunter is trying to confuse the jury, he is rowing a boat up a certain stream, or rather a certain creek. He's rowing a boat up a creek, and he does not have a paddle because the jury has already demonstrated via their questions that several of the jurors have a very remarkable understanding of medical practice. This isn't confusing at all.
And your responsibility was overseeing the CMO of that hospital.
My responsibility, my accountability to my bosses in Nashville was to make sure that that hospital was running. I relied on my chief medical officer as my right hand for making sure that that happened. But at the end of the day, if something went afoul, I had to answer to it.
And when were you working with those folks?
Began in the fourth quarter of 2018, and I finished in the fourth quarter of 2021, for 3 years.
So those 3 years, but during the time this incident took place, you were at Brandon Hospital, correct?
That's correct.
And at the time this incident took place, you had not worked in a pediatric hospital in 30 years, correct?
Again, that goes back to my clinical career.
Yes, sir.
Yes, sir.
But
might not be 30, but more than 15.
Clinical,
Going back to medical
not
school?
management.
And residency training. So up to 1991. It's pretty close. We're getting
I'll
old,
get back
aren't
to
we?
you. All right. That's all I have right now. Thank you.
Thank you.
Total loss. Total loss. No point. Alienated the jury.
Now,
Really
if
dumb
we
move.
could bring up,
Really dumb move.
I think what I was doing here is having, okay, this isn't confusing at all, is it? All right. Let me represent to you, and for the record, this is John Hopkins Children's Hospital. Well, actually, that's identified by exhibit.
We're not going to go through all this. I want to go to the argument when they go to break. Where are we? Can we go forward, forward, forward? This was where I lost timestamps because the afternoon began differently on law and crime. Give me the afternoon break. Give me the afternoon break. Come on. Here we go. Guys, this might be the ball game. For liability, this might be the ball game.
I'm trying to miss the question.
Oh,
Oh, yes, 2277-068.
And sir,
Yes.
I need you to step outside.
Happy to, sir.
Transfer should reflect the witnesses leaving at the court's request.
Your Honor, if I go to the bathroom, I will.
You're fine.
Thank you.
So Dr. Corcoran has testified for quite a bit. And over the hospital policies, the structure, how it gets understood. This argument is in relation to a document they want to show the doctor. When I said the doctor was a proxy, the doctor answered the way that you would expect him to. Would you do this in your hospital? Would you expect this of your hospital? Would anyone with your experience do the things that Jay Hatch did? And the answer was no. It was pretty simple. Hunter objects everywhere. But this document,
So what is this and how are we going to do it?
Your Honor, this is a risk management note from the hospital, and it is describing the circumstances of the videotaping. It's unfortunately one of the exhibits we would have used our lunch break for, but we had other issues. So pertinent to this discussion is that it relates to the October 18th to 20th videotaping in the EEG room, which was just discussed at some length. And at the bottom, you can see the various approvers, for lack of a better term. You have Dr. Sally Smith, Dr. Deese, and then pertinent to this witness's testimony, you have an authorization from risk. It says okay from risk. It describes in particular the videotaping, and it says no order relevant to this witness's testimony that there would need to be a progress note, a result, an order of some type for this not to be a failure by the hospital. And then
we're going to slow this down because we're not going to cover the testimony on this because it's honestly, it's saying it again, but I want to hear Whitney say it, and I want to hear it in real time.
And at the bottom, you can see the various approvers, for lack of a better term. You have Dr. Sally Smith, Dr. Deese, and then pertinent to this witness's testimony, you have an authorization from risk. It says okay from risk. It describes in particular the videotaping, and then it says no order relevant to this witness's testimony that there would need to be a progress note, a result, an order of some type for this not to be a failure by the hospital. And then it explains the circumstances of the videotaping and the rationale relevant to the consented treatment, which is the diagonal right in there at the bottom right says able to do when no one was there. So it's reference to.
Hang on, I'm going to pause. I'm going to read this for you guys so you can see it. So, October 7th admitted. Underline PICU. Arrow above that says no video, double and triple underline. October 15th, transfer Nemours. October 18th through the 20th. Video only, no audio. I'm a lawyer. I know what that means. It means you can overcome allegations of illegal recording because you didn't record audio simultaneously. The comment to the right of that, to prove if she can walk on her own. So October 18th to the 20th, video only, no audio, to prove if she can walk on her own. F68.10. Suspected Munchausen's by syndrome by proxy. Munchausen syndrome by proxy. Dr. Smith, Sally Smith, there's the other doctor. They sign off. Then on the bottom, they say no order, which in this context, the risk management means no medical order directing the treatment that we're talking about. Okay from risk, videotaping, no order. Then the little sideways note, it says able to do when no one was there. This was in the risk management file. This was in the risk management file. Yellow Pill, I appreciate the comment. Thank you for generous. You're killing me. Brandon Regional's garbage. You got McDonald's trying to compare itself to Chef Ramsay's restaurant. If you think J Hatch is Chef Ramsay's restaurant, I would encourage you to go listen to the rest of the Depos. I know that he was overselling his hospitals. That's not the point. I didn't care about his testimony. I didn't care. It was the note with the texts. So thank you, Yellow Pill. SJH has a children's hospital also. Like, they're not as innovative as this guy is trying to portray. I agree. I don't hate that. I don't hate that. But it's the note. Oh, yeah. Thank you for the clarification. I didn't mean to call you out. What did call out? No, just example in general. I wasn't calling you out. Just saying. This note is, and listen to the argument over it.
Well, that's it.
Notice.
Judge, we don't know who wrote this. We don't know for what purpose it was written. We don't know what these random cryptic notes mean. And this witness has testified that he's never reviewed the medical record.
You are so full of shit. You are so full of shit. You are so full, so full of shit. You're telling me that you are the chief general counsel for the hospital. He is on emails between risk management and himself as this process is going on. Those emails get redacted. You are so full of shit that you don't know who wrote this.
Comment on what should be in the medical record or what is or isn't in the medical record. So I don't know what this is being offered for right now, but there's no foundation for it. There's no demonstration of who created it, for what purpose, under what circumstances, or for what intended result.
Let me ask you more fundamentally, because I know we've been discussing this particular issue for 2 years now. Is the hospital's position that this was a medical procedure?
Yes, sir. This was part of a diagnostic procedure. We said that from the outset.
Well, then you're in the malpractice claim. It's coming in. That was a clever move by the judge, because the judge says, is the hospital saying it was a medical procedure? Now the plaintiff gets to introduce it in a malpractice claim, not the false imprisonment claim, not the battery claim. They get to introduce it in that claim because Hunter said medical procedure. Going on.
Okay, so then what's it doing in a risk management file? I mean, this
Next
is
question.
Risk management file, right?
This is from the risk management file. I can't tell you what this is doing in the risk management file, Judge. I suspect that they were asking.
Does anyone believe a word that's coming out of his mouth? Does anyone? Oh, Rob's pause game. I'm sorry for third party reference. My pause game is on point today. Look at Mr. Hunter. My gosh, the pause game is on point. Do we believe a single word Mr. Hunter is saying right now? The judge doesn't either.
If it was okay to proceed with that based on the consent that was in there, but I don't know that. I don't know what this means. And there is evidence of physicians indicating that they wanted to do the EEG video monitoring.
And after 5 years, no one has claimed ownership to this? Nope. That happens to be in the risk management file?
We think we know. I believe it was firstly. No, content. It was. I thought it was content. I thought it was content.
It might either be, well, it could be petty conduct, it could be least Kurth, but
who cares? From our point of view, it's.
I love this. Look at the attorneys on Hopkins' side when they say who cares. That's my view of it. I don't give a shit who wrote the note. I don't care who wrote the note. It's in the risk management file. I don't give a shit who wrote the note. So look at their reaction when he said that.
it might either be, well, it could be petty conduct, it could be least Kurth, but
who cares? From our point of view, it's a risk management. It's from the risk management file. It states there's an okay for risk management. It identifies people involved in it. And we're putting it in for the purposes of demonstrating exactly what the court just brought up, which is if this is supposed to be a medical procedure, why is risk management bringing in Sally Smith? Why is risk management bringing in Dr. Dees? Why is risk management involved at all if this is a fairly routine treatment or procedure?
Let me just make it more fundamental. Obviously, this is a hearsay document, but it is a statement by the hospital. So there is an exception.
Yeah.
So there is a basis for it. Clearly, it's relevant. Extremely relevant. So I don't see how I can keep this out, Mr. Attorney. But what other basis?
Clearly, it's relevant. It's extremely relevant. How do you expect me to keep this away from the jury?
Yes, I
Judge,
exclude this document.
there's no indication of what the document means, of who created it, or what the intention behind the so-called document is. I would venture to the comment that saying that this page of random notations is a document is stretching the word document a bit far. It came from the risk management file, I'll grant that, but the idea that it simply reflects someone having called risk management and asked, is this okay? And been told, yeah, that's not, number one, it's not relevant to particularly anything other than the fact that it occurred. And number two, it doesn't give this with these random jottings any kind of probative value or relevance.
Sir, the garbage that just came out of your mouth, I would like for you to process that again and say it again in a fashion that makes sense to normal people. What the hell? This argument was going nowhere. The second I saw this document, I had not seen this before, not this note. Yeah. Oh. And Hunter, I have made comments about attorneys that I litigate against. And there are a few, I will never name names, but there are a few who will walk a line so dangerously between what they can ethically say to a judge that's not an outright lie. What is just a very, 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 very loose extrapolation of the facts. And these are the attorneys that I find it hardest to litigate against. I made a comment to a friend of mine, a Florida attorney, in reference to this case today. And I said, I would both hate and love to litigate against this attorney. Because you hate it because they walk that line so delicately that when you call them out, if you don't swing and hit that thing over the fence, it's a whiff. That's a strike. And you only get so many strikes. You keep swinging and they keep walking that line and you miss enough, you strike out. And your odds of hitting an off-speed pitch that moves from top box left to the bottom, you might not be that good. You might not be that lucky. It's not that truth is subject to interpretation. It's that there's a version of facts where you leave out enough of the facts that what you're saying is still tied to the facts. Now, I don't like this. This has always bothered me. That's why I say I have issues with lawyers that do this. I always want, I want that challenge. But then again, it's really hard. Hunter knows damn well every fact of this case. He is in emails back and forth. He was involved when DCF made their removal. He was involved with risk management. He is in emails back and forth during these discussions. He knows damn well what that note means. Now, when I say he knows it, I mean he doesn't have actual knowledge. He would be an idiot not to reach that conclusion. But did he actually see who wrote it? No. That's what he's relying on. I didn't see who wrote it. I can't say who wrote it because I didn't see that with my own eyes. I know it was written. It's in the file. I've seen the handwriting. I know it matches other people. But I didn't see it written. Therefore, I don't know who wrote it. I don't know who wrote it. The judge has none of this bullshit. And Danielle, very appropriate. He understands what this note will mean to the jury if it gets in. He damn well does. This is clawing.
Well, here's where I'm just not following your argument, because this has been one of the most hotly
I
contested
missed
issues
that,
in
Brooke.
this
I'm
case.
sorry.
And you're telling me that a document from the risk management filing, that's one of the punitive damage claims, talks about the video, no audio, no order, to see if she can walk on her own suspected Munchausen syndrome by proxy. That this is not relevant. I mean, how is that possible?
Judge, the doctors were attempting to gather clinical information. There is a notation in the chart, patient transferred to room 709 yesterday for monitoring, continues to have pain all over, but reports she was able to get more sleep last night. Her PO intake appears to be slowly improving. The demonstration is from that note that it is part of the medical record, and exactly the narrative that's being promoted is just not correct. We don't have a date on this beyond 1, 2, 3, 4, at least a range of 6 dates. So we don't know what it was for.
Well, the jury's gonna get to see highly relevant, right? I don't understand why we continue to talk about it. We've talked about it for years. This is highly relevant. And
Yeah.
I mean, I guess yours and my definition of relevance isn't calibrated the same. So I just,
Assuming it's relevance, it doesn't speak for itself. So to give it to an expert to opine on before the person who actually put it in the record and can explain its contents, when, where.
Here's the problem. I made this comment yesterday with Hunter. I made the comment yesterday. You lead with your good arguments first. You lead with your good arguments first. Because when you make a bullshit argument first, and the judge's like, I'm not buying that bullshit. And then you go to your good argument. The court is so turned off from the argument that was just made that they're like, I don't want to hear this anymore. I told you guys, this happened yesterday with Hunter. And I don't know. Now he changes style and cross with this witness, but it's not the cross, it's the argument part. Like you are up a creek, my friend. You are up a creek and you're making an argument that has no chance of winning. Make the better argument. Make the argument that says you can't introduce it with this witness. Because what the plaintiff ends up doing, what Anderson ends up doing is just reading it to the witness. And the witness says, that's right, that's what it says. And no, that's not okay. Had Altenburg made this argument first, I don't know that Anderson would have been able to put this note in front of the witness. I don't know that that would have happened. But no, Hunter plowed ahead with the argument of going, I have no idea what this note is. And the judge's like, we've been at this for 3 years. We've been at this for 3 years. You know damn well what the note is. Stop trying to blow smoke up my ass. When the proper argument was, this witness doesn't do anything to this note. The note itself, that document, speaks for itself. You can't have some other witness opining on the document. That's pure speculation. To have a third party who didn't write the note look at it and say, well, this is what I interpret it to mean. That's speculation. That's a good argument. That gets kicked out. Not after Hunter did what he did. No. It's coming in. So what are we? We had knockdown punch, 8 count. I think the voir dire was a knockdown punch, but not. I mean, they got right up after that. This one is they're in a corner. They're in a corner, and body blows are coming, and the knockout punch is right around the freaking corner. This is
Where and how and why it was done. I mean, this is just the wrong time to use this document.
now that I am more akin to that type of argument, Mr. Altenburg, but it seems like this document is pretty clear as to what it means. So I'm going to go ahead and admit 2277-068. Can we take a break?
Yeah.
We'll be back in 10 minutes.
Your Honor, at least when this witness is concluded, I want a special instruction on the fact that violations of internal rules and policies and things like rights and responsibilities is not a violation of the law or actionable, but it can only be used as evidence. I mean, we need a limited instruction on what's going on.
Absolutely. Well, I suggest I'm going to get Mr. Elliott on the phone. You and he start talking about this. Okay. Thank you.
All rise, we're in recess.
For the hospital, you are now in nightmare territory. Bad move. Because now you have a witness who has talked up the jury. And let's just let him talk about the note that he didn't write. That has nothing to do with this. Let's let him talk about it.
All right. Now, Dr. Corcoran, I'd like to orient you to
A big ass water bottle he's got too.
a few phrases here. And the center bottom of the page here, there is an inscription that says okay from risk. And then and we can highlight that. Now, based on your experience and knowledge, and I'll represent to you, this came from the risk management file. Does this appear to be a form of authorization from a risk management department, given the circumstances?
Judge, conclusion like foundation relevance.
Overruled, you can answer.
Well, you make a bullshit argument. You alienate the judge. It's not going to save you. That was speculative. It was leading, and it called for a conclusion. That was an objectionable question. It was speculative as hell. But you make a bullshit argument, and the judge you have now told the judge, and the judge has reviewed the document enough that the judge is basically saying, I know what it means. The jury knows what it means. God. So the hospital just compounding errors. Who's got the Mike versus Rob count right now? Celine, you still got it? Because I'm doing okay.
I don't have enough information to make that conclusion, sir.
Assume for the purposes of this question that in fact
Didn't matter.
is referring to a risk management department.
Proxy.
Right. So if you then look up in the top right hand, it says that to see if she can walk on her own. Do you see that?
I do.
And then above that, it points and says something effective, no video.
Apparently in the PICU.
Right.
Right.
And then below that, it says video only, no audio.
Correct.
And then if you go down here, in this box on the lower right, able to do when no one was there, I believe. And then finally, on the bottom left, it says no order dash and above it videotaping. And I'll represent to you that this is from the risk management department. Now, based upon your background training and experience, does this appear to be an analysis of a medical need or an analysis of another need to prove something, a diagnosis or whatever?
Objection, leave, Roberts foundation.
This does not look like a traditional order, which would be electronically submitted in an electronic medical record. This looks like notes taken. You said it's from the risk management department, so I would say that these are notes taken of a briefing or a meeting.
I apologize. I stepped away. I want to make a comment at that point. I made a comment earlier about how the hell he can testify to this. He can't testify to this. He cannot testify to this. But Hunter has so alienated the judge that he is going to lose every argument that is anywhere near a 50-50 split.
Another need to prove something, a diagnosis or whatever. When no one was there, I believe.
Listen.
And then finally, on the bottom left, it says no order dash and above it videotaping. And I'll represent to you that this is from the risk management department. Now,
you cannot tell me that someone who's been in hospital work sees a single page document with these notes and can testify to a reasonable degree of certainty that that is what the note was intending to relay. We can speculate to all hell. I'm speculating all hell. But he has so alienated the judge is just done.
Based upon your background, training, and experience, does this appear to be an analysis of a medical need or an analysis of another need to prove something, a diagnosis or whatever?
Leading as hell. Leading as hell. Leading as hell. Doctor, would you like to choose option A, which is this little cookie, or option B, which is a massive cake?
Objection B, Relevance Foundation.
This does not look like a traditional order, which would be electronically submitted in an electronic medical record. This looks like notes taken. You said it's from the risk management department, so I would say that these are notes taken of a briefing or a meeting where it's decided based on this history, based on this need, we have the okay from risk to do videotaping without an order.
And then in the center of it, it says suspected Munchausen syndrome by proxy. I know you're not a psychiatrist or psychologist, but are you aware of whether suspect Munchausen syndrome by proxy is a diagnosis of a parent or a child?
Objection, Your Honor. Foundation, confidence, relevance.
What, if anything, do you know about Munchausen syndrome by proxy?
Same objection, it's beyond scope.
And finally, I'll point out here in the center above, it says Dr. Smith, Sally Smith. Do you see that?
I do.
And Dr. Dees and Dr. Smith, Sally. See that?
I see that.
And have you seen in the records where these two doctors were participating in the ordering of this video?
Objection, Foundation.
I have not seen that specific order, but I have seen both doctors referenced throughout the stay.
Okay. And have you had an opportunity?
This is great. This is great. And when I say great, I mean, like in trial practice, this is fantastic. This is what you see. Joe W., good question. Is the judge overruling all the defense's objections appealable if it should have been sustained? You can try to make the point, but the judge is exercising his discretion in allowing this information to come in, even though there's a reading of the evidentiary rules that would block it or that it could be leading. The judge could say it's context. There's enough in the record that would allow this to not be leading. It was asked as a question that didn't really suggest the answer in the fashion it was asked. This is playing a legal strategy and hoping like hell the judge sides with you on the law before the jury is there. And then I don't know. Forgetting where you are, forgetting what you're doing, forgetting who you represent, because Hunter starts objecting to everything. And not just like little objections, everything. And starts to look like a really whiny, annoying attorney. And the judge even, I mean, there's a sidebar where I think the judge kind of admonishes him. We'll get to that in a second. But right now, we're going to let Mr. Anderson take his victory lap. He did a lot of work. So did Whitney to get this in. A lot of work. They did a lot of work. So we're going to give them their victory lap.
To investigate, as part of your the assignment here, the role of Dr. Sally Smith in all of this.
I have.
And did it come to your attention that Dr. Smith was the director of child abuse education at Johns Hopkins All Children's Hospital during the relevant period of time?
Objection, Relevance Foundation.
I believe that she was head of that program from 2015 to 2018, if memory serves.
And let's pull up Exhibit 2116. That's in evidence, Your Honor. It's a committee, I believe. Messages. Now, if you take a look there with Dr. Smith, does it appear Dr. Smith and Dr. Paola Dees were messaging back and forth?
It does.
And so It says, FYI, we were able to move her to a video room last night. Staff has been making notes by watching her remotely. Apparently, she's currently sitting in bed with legs crossed and has a laptop or something propped up on her lap. You see that where it's written there?
I do see that.
And I'll ask you to assume for the purposes of the question that the videotaping in question occurred October 18th and 19th, 2016. And then below it says, we may need to try to monitor what she's doing online. I wouldn't put anything past her mother.
I see that.
Objection, Your Honor. Reading the document speaks for itself.
Very good. So if this type of communication was brought to your attention in your roles as director of, again,
chief medical officer,
where two doctors were conversing in this manner about a patient and a patient's mother, what, if anything, would be your concern?
Objection, Your Honor. Speculation, foundation, relevant.
At a minimum, I would address their method for discussing the case and the tone and characterization of their discussion.
Does this tone and characterization, based upon your knowledge and position, both as a physician and as a medical director, does this appear to be a compassionate concern for a little girl?
Objection, foundation, relevance, leading, speculation.
In a word, no.
And should doctors be trying to set up their patients to see?
Let me read this note. Sally Smith to Paula Dees. Fortunately, at 10 years old, she can't perform the charade effectively 24/7 and doesn't even know if she's making, quote, psychological, end quote, mistakes. I'm coming to take some pictures of her, quote, affected, end quote, legs for court on Tuesday. My blood was boiling. Boiling. I have been, physiological. Thank you for the clarification, Lady Drake. And doesn't even know if she's making, quote, physiological, end quote, mistakes. I'm coming to take some pictures of her, quote, affected, end quote, legs for court on Tuesday. Paula Dees text back. Absolutely. Paula Dees text back. Could we record some more to see if we catch that for court? 3 question marks. I have read some texts. I have seen exchanges. I have seen reports between CPS, DCF, doctors, providers. This is planning. This is fucked up. This is really fucked up. Fortunately, at 10 years old, she can't perform the charade effectively 24/7. And doesn't even know if she's making physiological mistakes. I'm coming to take some pictures of her affected legs for court on Tuesday. Absolutely, Sally. Could we record some more to see if we can catch that for court? Question mark. Dr. Corcoran wasn't here. This Dr. Corcoran was the polished resume that got to reaffirm the jury that what they were reading and what their gut told them was acceptable. Dr. Corcoran was there to reassure the jury. You're reading this, and the feeling you have is appropriate because I have it too, and I've run hospitals. That was his purpose. That's why the defense did not want him there. They didn't want these in the record, and they certainly didn't want someone who has run a hospital telling them it was okay to feel the way they were feeling about reading these texts. That was his whole purpose. Whole purpose. We spent the whole afternoon for this feeling that the jury now feels. And it was an afternoon well spent by the plaintiffs. because I can tell you right now, it is a fucking uphill battle for the defendants to come back from this. That deck and how that thing is stacked just changed in this case. Because I thought the plaintiffs were a little bit awkward in the points they were making. Not here. Nope. Not in the slightest. Dr. Corcoran made the jury feel okay for feeling disgusted by this.
If their symptoms are correct or not? Or
I'm
real
sorry?
Or not? Should doctors be trying to set up their patients to develop, for lack of a better term, evidence or proof against them for their diagnosis?
Objection to relevance, 403.
Mr. Corcoran, can you re-ask that one for me?
Should doctors be trying to set up their patients to develop, for lack of a better term, evidence or proof against them for their diagnosis?
It's the same one.
Big face making a point. It doesn't matter what Gregory Anderson says. It doesn't matter what the question is. It doesn't matter. He doesn't care if they're sustained or overruled. He doesn't care. He doesn't care. He has the document displayed on the screen. He doesn't care. I wouldn't care. I'm not pro anybody, plaintiffs or defense, but this is a self-own. This is a I stepped in it and I don't know how to get out, so I'm just going to keep yelling things. Oh. Where's the sidebar? Hang on. Right,
I'd like to pull up two.
So Dr. Smith was head of an outside agency, but had an internal.
No, I'm going to sustain the objection.
Okay. What, if anything, did it appear to you in reading through this as to Dr. Sally Smith's role at the hospital?
Excuse me, I object. I don't know what he's reading through. I don't know what's being asked.
I assume you're talking about the committee list?
Yes, her overall role at the hospital based on the what we've already.
Where's the other one where he tells Hunter to cut it out? There it is. Here, hang on here. Because I think he tells Hunter to cut it out. No. No. It's after this. Okay, so Hunter starts acting like a child. Let's make him spit. Child.
I'd like to publish then 2045-005. This is a statement. Actually, is this an evidence?
Yes, it's an
All right. May we publish, Judge?
It's an evidence, yes.
All right, I'd like you to review that statement to yourself, please.
Iris, don't understand how the handwriting note is legit. That was in the file, in the risk management file that was turned over to the plaintiffs. Plaintiff said, give me the risk management file. Tell me everything that you reviewed to determine that you had to do these things. And the hospital goes, well, it's a subpoena. I have to give it to you. And they say, I hereby authenticate as the hospital that everything in this file is true and correct to the best of our record keeping. And they say, here you go. So it's a legit note. It's legit. The hospital knows it's legit. They just play this game of not knowing who wrote it. Yes, Ms. Deanne.
Do you have an opinion based upon your background, training, and experience into a reasonable medical
Thanks,
management
ma'am.
probability as to whether, based on your review of the facts of this
Thank you,
case,
ma'am.
Johns Hopkins All Children's Hospital lived up to or complied with the statement by Dr. Mueller?
Objection, Your Honor. Relevance, foundation, lack of predicate in 403.
Sustained.
What, if anything, did you see in this organization to indicate that there was a defined chain of, well, that there was a defined leadership or lack thereof?
Same objection, Your Honor.
Overrule that objection. You can answer that.
Thank you, Meg. Very generous.
So it's the indications have been consistent that quality assurance and performance improvement was to be organized at a division level.
Elizabeth, good point.
And the divisions report up to departments. There appeared to be no system-wide approach to quality assurance and performance improvement.
What's the problem with that?
Well, for start,
Objection, Your Honor. Today he's calling for a narrative answer. He's calling for a lecture. It's outside the pleadings. It's 403 violations of rule.
Counsel, speaking objections. Now this becomes whiny.
so first, it's an expectation that I was held to every time that I was at the facility or division and participating in a regulatory survey, that we could demonstrate a system-wide approach.
Why is that better?
Well,
You can answer.
it sounds great to have everyone responsible for quality and patient safety, but we've all experienced it that when everybody is responsible, nobody ultimately is responsible. So without oversight by a leader like a VP of quality, a VP of medical affairs, a chief medical officer, somebody to make sure that there was a consistency, you had wide standards from one division to the next, and that creates gaps where patients can fall through the net. And this, my experience in reviewing the system that the leaders have addressed and touted, is that this was really a system-wide failure that allowed Maya and potentially others to fall through the gaps.
Do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether the system that was set up by Johns Hopkins All Children's Hospital in operation provided sufficient safeguards to protect children in Maya Kowalski's position?
Objection, Your Honor. Foundation, relevance, 403, improper expo.
Sustained.
What, if any, opinions have you formed about the ability of the system you just testified to protect children who are in a situation such as Maya Kowalski was during October 2016 to January 2017?
Same objection, Your Honor. You're saying the same question.
I agree. Sustained.
What changes, that's like that. How would this system have to be changed, in your opinion, in order to ensure that situations such as a child being allowed to, or being photographed without authorization on 2 occasions, a child having what we discussed before with the not being allowed to see her priest, having things taken from her, these type of events from happening?
Objection, Your Honor. Relevance, 403, leading. It's also fails to take into account DCF and Chapter 39 involvement, and it's outside the plea.
That's
Dude, if you're going to say that much, file a motion. That was every objection and trying to tell the jury, we're protected, we're protected, we're protected, fails to take into account Chapter 39. I would have, if I'm the judge, I'm instructing him right there. You don't make that objection. Not there. Fails to take into account Chapter 39 immunity. No. You don't instruct the jury on the law. I do. From the judge. You don't instruct the jury on what they can and cannot hear. I do. You don't tell the jury Chapter 30, failure to take into account Chapter 39 immunity. That was garbage.
You can answer that one.
So the quality assurance and performance improvement function would need to be overhauled so that it was system-wide. And that's actually something that Hopkins is recognized as a leader in. So the expertise should be readily available to the team at Johns Hopkins All Children's Hospital. But that would provide a consistency from division to division, and create a safety for patients as they're being handed off from one caregiver to the next.
Do you have an opinion based upon your background, training, experience into a reasonable medical management
probability as to whether the system in place provided sufficient safeguards for children at Johns Hopkins All Children's Hospital during the relevant period?
I do have an opinion.
And what is that opinion?
Objection, Your Honor. Relevance outside the pleadings, improper foundation.
But I don't think you tied it to Maya Kowalski, so I'm going to sustain the objection.
Same question as to the care and treatment of Maya Kowalski.
I do have an opinion.
What is that opinion?
I do believe that the system failed Maya Kowalski and her family during her stay, primarily because the architecture was so siloed that there were gaps in the safety net that let her care fall short.
Your witness.
What a disaster. What a disaster. Oh. Slow motion train wreck.
Good afternoon.
Good afternoon.
Once again.
Yes, sir.
Your Honor, court, please, can I first approach the witness and ask to look at the materials he's reviewed?
That is pure intimidation. That is, oh, Hunter. Oh my God. I'm sorry, sir. You have an attorney calling you out because I know what the hell that's for. Oh. You already saw him. You saw the documents. You know what he's looking at. You're trying to get close. Oh God, it's a slow moving train wreck into a wall full of concrete with dynamite behind it. This doesn't get better. Hi, Sam from the Netherlands.
Sure. I'll get this back.
No worries.
Honest.
Island, good point. They won't. They actually have budgeted pretty accordingly. I think they've got plenty. They both do. They've both done pretty well, given the time constraints. Mispronounced name. Would I take my niece or nephew there? Not at this trial.
Okay.
LJ Peach. Yep, that head's pretty red. What are the any? Zero policy changes since the event. It's alarming. I tend to agree.
Thank you, sir.
Yes, indeed.
If I understand correctly what you just showed me. And what I will like to ask the clerk to mark when we get through here was a complete list of everything you've reviewed about this case. Is that right?
It is a list of everything that was provided to me. Yes, sir.
Okay. And it was provided to you grouped by issue. Is that correct?
By date and by issue.
Yes. So in other words, if they wanted you to look at issues relating to the surveillance video, they sent you documents regarding that, correct?
That is correct.
And if they wanted you to look at corporate documents, they sent you a group of documents related to that, right?
That's how they're grouped. Yes, sir.
Okay. And if they wanted you to look at examples of Dr. Smith directing care, they sent you a group of documents related to that, right?
And you, Joshua. Thank you.
Yes, sir.
Okay. And then if they wanted to have you look at particular documents regarding the surveillance video, they sent you documents related to that, correct?
Yes, sir. That's one grouping.
Okay. So do you have any idea how many pages of policies and procedures and documents have been produced?
Hang on. Shiraz, roughly how much should we to raise for transcripts? Ballpark it? No, I can't. And I'm not going to even facilitate that in the chat. Stop trying to raise money for transcripts. Transcripts like this are in the tens and tens and tens of 6-week trial. 6-week trial. It cost me about $1,000 to get a day's worth of transcription. We're not. Now, if the hospital appeals and they have to file a transcript, there might be the ability to copy, but do not contribute to that fund. I appreciate the curiosity. I'm curious as well, but please don't. Lita, thank you for the comment. Lacrosse is a great sport.
in this case?
Have been produced to me
No, sir, to the
in general.
parties
I
that the hospital has produced,
I understand
the
that there-
plaintiffs have produced. Any idea?
I understand the number is in the tens of thousands.
We can agree, can't we, that you didn't get tens of thousands of documents?
No, sir.
You didn't come anywhere close.
And for the scope that I was evaluating, I didn't need the entire.
Well, so that we're clear, we covered this a little bit earlier, and I'm not going to go back into what I asked you before, except perhaps by accident. But you're board certified in osteopathic medicine, but you've never held yourself out as a pediatrician, correct?
I am board certified in obstetrics and gynecology. I have a
I
grad.
see. I'm sorry. I beg your pardon.
No worries, sir.
You're an osteopathic physician.
I am an osteopathic
And
physician.
you're board certified in obstetrics and gynecology.
Yes, sir. That's correct.
And you've never been trained as a pediatrician.
That is correct.
And you've never held yourself out as such.
That is correct.
And as far as your opinion in this case, it presupposes that the diagnosis of CRPS for this young lady was correct, doesn't it?
No, as I explained to you during my deposition, it presupposes that the proper approach should include an evaluation for CRPS.
I see. Okay. Did you ever look at any records of this young lady's care from Lurie Children's Hospital?
Not from the hospital, no.
Did you ever look at any from Tampa General Hospital?
No, I did not.
Did you ever review any complete medical record in this case?
Medical record, no.
Okay. And the depositions that you seem to have reviewed in this case, looking at your list, seem to be somewhat limited. Is that right?
Yes, sir. I think that's fair.
Okay. Well, you reviewed Sally Smith's and Ms. Beatty's and Dr. Elliott, Ms. Condon, Ms. Crane. That's about it, wasn't it?
No, sir. Dr. Perno.
Okay, Dr. Perno,
Dr.
Napolitano.
Napolitano. There were others.
There were others. Did you ever review Dr. Michelle Smith's deposition?
I don't recall that name.
Okay, well, that's a good thing because she wasn't deposed. Here's what I meant to ask. Did you ever review?
Dang it. That is twice. Oh, no. Hunter just played a game of gotcha. You don't get to play gotcha with a witness. You don't get to say, did you review the deposition of someone who was not deposed? That can get you sanctioned in court. Because what if he said yes? You don't get to say that. That's bullshit. That should have been an objection. But he's not objecting because Hunter's just first thing to do when you find yourself in a hole, stop digging. Put down the shovel. Put it down. Mr. Hunter, step away from the shovel. Please. Please step away. Stop. Stop. You're halfway to China. Stop.
You her progress notes from the PICU.
I did not.
So you have no idea what efforts were made to transfer this patient during the first week that she was at All Children's.
I didn't review the medical record references to transferring the patient.
Okay, so you don't have any idea what they contain.
I never reviewed the medical record, so I have no insight into what was in the medical record regarding the transfers.
Okay. Now, let's go back to what you haven't looked at. Did you ever look at Dr. Hanna's records? Ever see his records at all?
Not his records, no, sir.
You never saw Dr. Kirkpatrick's records?
Not their treatment records.
Okay. And you've never seen any order in the chart regarding the EEG video or seizure monitoring, have you?
Again, I have not reviewed the medical record because that's not the area of expertise that I've been brought to assess.
Well, you've expressed some opinions regarding the EEG video. What I'm trying to find out is, have you looked at the chart to see what's in the chart about that video?
I don't think that reviewing the charts are necessary to inform the opinion that I shared a half hour ago.
Okay. But you did indicate in that opinion what you thought the chart should contain, right?
I was asked to review a memo. I shared my opinion or insight about that memo.
Were you ever provided any of the court orders regarding this patient?
I don't specifically recall seeing the court orders. I may have, but
Hunter, you're getting nowhere. You are getting Nowhere. You have done nothing to damage the credibility of this witness. Nothing. Did you have ammo? Maybe. I don't know. Jury questions.
Confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And I want to confirm that you've not been approached by anyone about this case since you were last with us.
Oh.
And you did not see any media accounts. Is that correct? Okay, Dr. Corcoran, the jury has several questions. First question, if you know, is Dr. Dees and Dr. Sally Smith still at Johns Hopkins All Children's Hospital?
I don't know for certain. I understand that Dr. Sally Smith has.
If you know or not.
I don't know.
Thank you.
This allows me to bring up two questions I saw earlier. Christina, how is J Hatch linked to SS for fault? She's still employed. What's your thought on the repeated jury question if Sally Smith still works there? That intrigues me. She's still employed there. They're going to find out. They're going to find out. But the judge has said it's too complicated. We're not going to just do it in that format. We're going to allow it to be presented. Oh, God. Sally Smith. Oh, still employed. Still employed. Still employed.
Okay. Next question. If parents have ongoing concern regarding their child's daily care and treatment at the hospital and expressed it often to the staff, would the parents be advised as to the proper chain of command they should contact to voice their concerns?
That's a very reasonable expectation, and I believe that that's the way it should work. I can't say that the system in place in 2016 provided for that.
Were the Kowalskis told they could contact senior executives to voice their concerns via email or otherwise?
I don't know the answer to that.
If medical staff works independently of the hospital, then who holds them accountable?
That's a great question. And the Medical Executive Committee, which I was a member of for 4 years when I was in practice, is responsible for oversight of the physicians for quality assurance, performance improvement. And the Medical Executive Committee has a relationship with the board of the hospital so that everyone's on the same page. I hope that answers the question.
The next question, and for the author of this one, I'm only able to ask one. Have you assisted in a case with a Munchausen by proxy diagnosis in your career?
I have not. I practiced obstetrics and gynecology. I'm happy to say that that was not part of my experience.
Next question. What is the acute quote, the acuity of the bed, end quote? What does this mean?
That would be a better question for Mr. Hunter, but I believe that he was referring to how sick of a patient can you care for?
Yeah.
Some hospitals, like Venice Hospital, when it was
What we
around,
can do.
was a lower acuity. Sarasota Memorial Hospital takes care of sicker patients, so it has a higher acuity.
Mr. Anderson, that completes the jurors' questions. Do you have any follow-up questions?
No, sir.
Mr. Hunter, do you have any follow-up?
No.
And may this witness be excused?
Please. Although he's still understood.
Okay, so you're free to.
Okay. He's done. They had an argument. I want to get through super chats because I did not expect this to go 3 hours. I do very much appreciate there are 4,500 of you guys watching. This is the biggest stream we've had so far on the Kowalski case. If you have liked the coverage, if you like the recaps, I do these every night. Programming announcement. I can't do one tomorrow night. I have a law firm partner meeting that's in the evening, so I can't do a recap tomorrow, but I will recap on Friday before FNF. So if you are here watching for the first time, God, I've been up since 5 and I went to sleep last night after the recap. Compose thoughts. If you're here for the first time, if you would consider subscribing, I would very much appreciate it. I have been following this case. I am a full-time practicing lawyer. I do have the real law firm job. I was in court today. Trying to listen to the testimony at 2x speed and do a recap at 8 p.m. at night is challenging, but this case is worth it. And people have shown enough interest in it that I really do want to give it a fair representation of what's going on and give my assessment of it to try and explain the things that are happening in court. So please, if you wouldn't mind liking, subscribing, the YouTube things that I hate saying out loud, It'd be very much appreciated. I'm going to go through super chats. I'm going to go, there are almost 30 of them. I'm going to try to get through as many and as I'm going to try very, very hard. But again, it's really late and I'm trying. I wanted to run late because I wanted you guys to, I wanted you to see the testimony. And yeah, I need food. Creed M, at the end of the day, Shapiro said the plaintiffs should stop this. They don't want the defense to do the same thing. They did. Island, most people I know who've been in DCF custody have had pics like this taken. Yes, it's common and it's terrible. It is. Lorna, can you settle during the trial if it's going bad? You can, but if the other side know it's going bad, their settlement offer changes. So I don't think it's palatable to the hospital. Tara Pezek, do you think the plaintiffs are setting themselves up appropriately to tackle the fine line that is at the heart of the case? I think the plaintiffs have allowed the defense. I go back to the remark the judge made yesterday. Part of the fault in the line and the muddying of the waters falls on the hospital for hiring Sally Smith and for blurring that line with their employment. So I think the plaintiffs have done enough to produce evidence where the judge is of that view. And the instruction on parsing the lines isn't going to be as firm as it would have been if the evidence had not been presented by the plaintiffs. Beach Lady. Rob, I've been a medical records director for 20 years. I have never worked for a healthcare entity who didn't have a consent for photos that was separate from the consent to treat. It's too high risk. I don't disagree. JM, 50 years in healthcare from direct care to educator to administration. I am ashamed. J Hatch has turned medical care into an oxymoron. Again, plaintiff's case. We don't know the defense case yet. Misty Ann, do you think this case will set a precedent for hospital rights over patients? I think that hospital risk teams are reassessing exposure. I think they're reassessing what they should do, how they should manage cases like this. I think they're reassessing staff and saying, are we going to directly employ someone who's contracted with DCF? Do we want to play that game? So, happy Annie. Thank you, Robin. Jules, you both have been so insightful and invaluable in understanding so many variables of this case. I haven't missed a single recap and hope I don't have to. You're both amazing. Happy Annie. Thank you. That is very kind. And it makes me feel very good for doing these. It gives me the energy to do them. Laura Leanne, should we be concerned? Defense is retired appeals judge. No. No, they don't have any additional sway. It's just their arguments. Yellow Pill 17, Brandon Regional. We covered this one. Brandon Regional is the worst hospital in the area. Like, you have no idea. Ask anyone in the area what they think about BRH and you'll get a slew of cursey words. I saw your comments. Thank you for that. Kevin Oak, why would defense wait till today to ask he not testify? I don't know. That should have been argued well before today. Whiskey Sour, Rob, is it still an option for J Hatch to settle to avoid the possibility of bad press upon a loss? It's a $220 million lawsuit. Their med mal liability coverage is not that high. It's a lot of money they don't have. I don't know that they will. Baby Gator, is that a unicorn that screams? Is that a unicorn that screams like a goat? If so, I absolutely need one. I received 4 of these from you folks to my P.O. box. 4. Now, well, stray hair. Behave, hair. Behave. Come on, hair. Now, here's the fun caveat. I gave 3 of them to my nieces and nephews. and I taught them how to use them. So they now walk around the house going like this all the time. See, Uncle Rob is fun. Yes. So I cause chaos. Misty Ann, able to do when no one was there. It can refer to two things. One, the hospital was able to do it when no one was watching, or that Maya could have been able to do the things when no one was watching. My inclination is that that note was intended to show what they were trying to prove, that Maya was able to get up, go to the bathroom, move around the room when no one was watching. Horse welfare. I am a victim of blatant medical malpractice. I am sorry for that, horse welfare. The lawyers for Kaiser Permanente were exactly like Hunter. Unfortunately, Kaiser Permanente also forces their members into their own arbitration system, no court trial. That's interesting. I didn't know they could do that, to be honest. Peggy Reardon, why is more than one attorney allowed to argue? The judge wants to make the right decision on the law. When it's a witness questioning, you don't want people ganging up on a witness. But on the law issues, the judge has been pretty good about allowing the attorneys to present their arguments so the judge has a full understanding of the law. You saw that with the motion in lemonade. The judge really did want to hear from everybody because the judge was like, I'm getting this now. I need you to tell me what your arguments are, and I want to hear all of them. So, Night Owl, I saw this comment. I wish Emily was covering this case. I talked to her about this case. We have a group chat. I have a separate chat with her. I give her updates here and there, but honestly, she can't cover cases involving kids. She has said it's too close to home for her, and I very much respect that. This is my wheelhouse. I deal family law. I deal with this stuff all the time. Emily has two sons, remarkable young boys, and I can see why she would have a personal take on this, why she would feel personally about some of the testimony, because she has boys that boys are boys. They get into accidents and do stuff. I know that there have been remarks about people wish I could cover it live while it's being aired. I do have a full-time legal job. I have clients, I have hearings, I have court. I wish I could. I really do. Because I'd love to be able to talk to you guys during these breaks, but I can't. So I have to do the recaps. So Night Owl, I thank you for the positive encouragement you give in the chat. And I hope the explanation kind of at least gives an explanation. Lady Law Sandra, Rob, why this case such a mess? Are all civil the same? No, not really. This case is 5 years of litigation. I mean, there were 52 motions for summary judgment, 52 orders for summary judgment. Those are orders that have to be navigated. This case is exceedingly complex. Melanie Hideki, plaintiff has a great case, but we still have to hear the defense. I 1000% agree. There's a lot of claims that can just disappear based on what the defense proves. I'm waiting. I have told you guys I will shoot this straight. I promise you that. I will give you a down the line interpretation of what I am viewing as I'm viewing it. And when we get to the defense case, a lot of you are going to have a lot of opinions about what I'm going to say because it might be opposite of what you think. I will say today this was a devastating day for the defense. This was a very good day for the plaintiffs. So, Lyrebird, Lyrebird, I see now what you meant about how you order things for the jury. This feels a lot more impactful having heard everything else. That is what I was trying to explain earlier. We arrange our cases so that they have impact in the right moment. So you hear evidence at the right time that gives context. People use the remark and they do it inappropriately, where they say the jury can't comprehend. That's not really the case. If you give someone a piece of the story out of order, it doesn't make any damn sense. Let them hear the piece of the story in order. That's the point. J. Michael RN, not all healthcare professionals use EHRs, even at hospitals. Even hospitals with EHR, some units use mixed records. Interesting. AG, for good transcriptionists, pay on our end from a larger firm can exceed 75 to 90 audio per audio hour. So $90 per audio hour. It's really expensive. It is. Linnea, Mr. Hunter, and Herbert will be sitting in the hole later that Hunter kept digging, sharing a drink. Thanks for all you do, Rob. Thank you, Linnea. Tara Rayner, court went well today, kicking ass, taking names. We were able to, with a lot of negotiation and persuading the judge that the attorneys had a good handle on the case, we were able to get it resolved and continued in hopes that we can reach an ultimate resolution in the time between now and the ultimate trial date. It was a lot of work, but we got there. Yellow Pill 17. I don't care who this dude is anymore. There's no recovering from those messages. They're pretty tough. Gotcha, the Frankenfurter. That was an eye-opener today. Thank you, Rob, for explaining everything. Have a good night. Thank you very much. Anna Josky, feel like Hunter's continuous objections, which a lot are overruled, show how damaging his testimony is. What are your thoughts? I thought that was foolish. Very foolish. Because Anderson was going to rephrase the question however he wanted. He didn't care whether the answer came in or not. He wanted to rephrase the question. I don't care how confused you make Anderson by having him rephrase the question or restate the question. He didn't care. That note is sitting up there in front of the jury. I thought this was a terrible miscalculation. Terrible miscalculation. When he approached the bench, I think he should have said, Judge, I want the court to note that I have a running objection on all of these grounds. Every question asked, I have a running objection. And the judge would say, Mr. Hunter, thank you for not interrupting the jury, and I will note that objection for the record so that it is preserved when you want to appeal. Objecting over and over just drew attention to how bad it was. Melanie Hideki, if you were my kid, I would be so proud. Thank you. KBT, thank you, Rob. Please take care of you first. Heart all you do. Well, tomorrow, like I said, law firm dinner. No recap, less stress. I will get some rest, I promise. Fiore Nudie, thank you. Ange Torres, thanks for the gifted memberships. I do want to call those out. StreamYard started saving those, but they're not consistent, so I do have them saved separately. Lady Law Sandra, I'm in school. I hate family law. That's okay. A lot of people do. A lot of people don't practice this area of law. I do. I have told people I am in disaster recovery. My job is to get a client from one end of a life that seems like there's not a whole lot left to another end where they can begin anew, building something back, and to kind of shuttle them along the way and keep them safe along the way. It's a difficult task. There's a lot of emotion, but I thought I would hate it, but I actually really appreciate doing it. I like it. It sucks. It's really hard. It's really hard. There's a lot of emotion and people bring you into that emotion, and it's tough, but it's also remarkably rewarding because you're dealing with something that's so important to people, their family. It's the most important thing in the world. So that's why I do it. Because I get to protect the thing that's most important to every single person who has a family is their family. So that's what I do. That's what I like to do. Okay, so I want to call it gifted memberships. Joshua Tenhog, thank you for 20 gifted memberships. Ange, 15 gifted memberships. DSN, gifted memberships. Ryanman YYC, 5 gifted memberships. Alex, 5 gifted memberships. Leanne, 10 gifted memberships. Fiona W, 10 gifted memberships. And Baby Gator at 10 gifted memberships. You guys are exceedingly grateful or exceedingly generous to the channel, and I am exceedingly grateful for all that you do. Exceedingly grateful for all you do. Golden Hermit, why did I go into family law? Okay, story time. That's fair. I wanted to be a swivel chair lawyer. When I was in law school or before law school, I had this grand notion. My parents were engineers and they've grown up in business and they were in business. And I wanted to be the lawyer that was in the back office, that wasn't in court. I wanted to be the swivel chair lawyer. I wanted to be the person that helped people make decisions. When I graduated law school, market sucked. There was no one there. There was no way I could have done it. I had done well in family law, like in law school. I took family law and I booked the class, which means I got the highest grade in the class, in the school. And I liked it. I understood it. But I didn't want to do trial. I really didn't want to do trial. I didn't want to be a trial attorney. I graduated and wanted to be a behind the desk lawyer that consulted execs. No consequence, right? It's just billionaires and money. When I graduated, no one was hiring. So I went to work for a solo practitioner. Out of law school, I made $35,000 a year. Barred as an attorney that could practice law. $35,000 a year is my first job. This was in 2010, 2011, beginning of 2011. And the solo practitioner I worked for, I needed a job. I was in court the first week. The first week I had that job. The first week I was in court. To the point where I think I've told the story before, where the judge, I went to the Commonwealth's attorney because the person that hired me said it was just a first appearance. There would be nothing to worry about. Just say continuance. Commonwealth's attorney, Mr. Bradley Marshall, still a buddy, said, no, we're trying the case. I didn't know any better. Wait, what? We're trying the case? Yeah, we're trying the case. Go into the courtroom, and the judge, you step in front of the bar. And that's what, when they say it's a barred attorney, that means you are allowed before the bar. You're allowed to approach after that little rail. So I approached, and I was at the table with my client. And the judge says, we're going to begin the trial, opening statements. No, Your Honor. No, Your Honor. Would you like a rule? And I looked up at the judge and said, what? I said, Your Honor. And he goes, Mr. Moore, would you like a rule that excludes witnesses and potential witnesses from the courtroom so they don't hear each other speaking? God, I love good judges. I love good judges. That was a good judge. He didn't make me feel like an idiot. He guided me. I said, yes, Judge, I want that. Yes, Judge, I would like that. Yes, please, please. Yes, I want that. So that was my first trial. And then I had one day, several weeks later in federal court. And I remember walking in front of the bar, and in federal court, in bankruptcy court, there's a podium, and you go up to it and there's a microphone, and it's broadcast the whole time. There's microphones at every court, but I remember saying Rob Morton for the debtors, and hearing my name, like hearing me, like I looked over my shoulder. I looked at my clients. I was arguing over their house and whether they could keep it. And I knew I had the law. I knew I could make the argument. And I was so distracted by the noise resonating in the courtroom that I kind of lost focus for a second. I looked back up and the judge is smirking. Judge Brian Kenny. That moment Yeah. I was never going to be I was never going to be a swivel chair lawyer after that. Once you realize that trust, once you realize what you have, once you realize what your clients have given you, no. So litigation is where I belong. I belong in a courtroom. That's where I want to be. So, somebody go to bed, go to bed, go to bed. Go eat and sleep. Yes, I know. I know. Icosaplex, thank you for the additional gifts and memberships. Melanie, Vicky, thank you. Melanie, again, stick with it. So much help with foster care. Yeah. It's a really important area of law. Fiona W, thank you. Baby Gator, thank you for gifted memberships. You guys, thank you for everything you've done. Thank you for letting me talk. Thanks for following the case. Please consider subscribing. It means a lot. Share the video. Share the fact that we're covering this case. I won't see you guys tomorrow night, but I will see you on Friday. So good night, all. I hope you have a pleasant evening and a very happy Thursday. I'll see you on Friday.